Testing 1 2 3. Testing 1 2 3. Test, test, test. This is a test of the Seventh Circuit Court of Appeals.
Good morning, everyone. Welcome. Our first case for argument this morning is Harold Johnson versus Statewide Investigative Services. And I believe we have Mr. Gomberg online. Is that right?
Yes, Your Honor.
All right. Can you hear me?
I can.
Great. Then you may proceed anytime you're ready.
Thank you, Your Honors. May it please the court and counsel, I do want to thank the court for allowing me to do this by Zoom. The lower court, as you know, determined that Mr. Johnson, whether or not he was a supervisor, was a material issue of fact. If a jury finds that Mr. Johnson was not a supervisor, then it can also find that the statewide reason for terminating Mr. Johnson was a pretext for age discrimination. As you know, Mr. Johnson was demoted 2 years approximately before he was discharged. And when he was discharged, and before that, he asked if he could work part-time.
So, Mr. Gomberg, with regard to that point, where in the record is evidence that he requested from the supervisor or from his immediate supervisor that he be allowed to work part-time?
It was in one of the answers to the interrogatories, Your Honor.
Okay, is it anywhere else other than answer to the interrogatories?
It may have been mentioned in his deposition. It probably was, but honestly, I don't remember offhand.
Yeah, when I looked through his deposition, I didn't find any reference to him mentioning that. The interrogatory responses, did you place that before the district court in your opposition to the motion for summary judgment?
Yes, Your Honor.
Mr. Gomberg, to follow up on that, your response to the summary judgment, the specific docket entry is 88. It's Plaintiff's Local Rule 56.1B3, response to facts and statements. Was there ever a request made by Mr. Johnson to have an opportunity to properly support the position, meaning sometimes it used to be called 56F, sometimes now it's called 56D. When facts are unavailable to the non-movement, they can request from the court an opportunity for further discovery. When we see arguments from a appellant that they haven't had an opportunity to sufficiently explore the record, that's one of the things we can look for, is whether or not there was a request to do further discovery. Did that take place here?
I don't remember a request to do further discovery. What happened, as you may know, is the other side stopped the deposition in the middle. They were claiming that I was talking to Mr. Johnson when I was just asking my clerk for a cup of coffee. And so they stopped it. The magistrate judge gave them an opportunity 3 times to restart the deposition. And then they decided they never did so. And that's why we filed the declaration that you're aware of.
What does the record tell us about how he was classified for pay purposes? I thought there was some evidence that payroll records established that your client was a supervisor throughout the relevant time period.
I'm not aware of that, Your Honor. If there is something, it's not something that I remember seeing. And I know that the issue in terms of pay was like $1 difference between what Mr. Johnson was getting and the new younger people that were hired part-time right after him. And there was an issue regarding his wearing a shirt, a white shirt, which that was the testimony about that was that they didn't want to spend the money to give him a blue shirt, so they said it was okay to keep a white shirt. But there is no other evidence that I'm aware of that indicates after the demotion that he was a supervisor. And in fact, he testified, Mr. Johnson did, that he never did anything either before or after the demotion that was different than what regular guards did. He never actually did supervisory duties. And as you know, there was some flack about the fact that he had a Facebook page that had a name of a chief security officer, and they were wondering why that was there. And Mr. Johnson testified about that, but didn't get to complete his testimony and clarify why that was still on the Facebook, but he said that he didn't even remember that he had that at one point. And of course, you know, I mean, he was 77 years old, not a youngster who knows how to do computer work, but I'm not aware of anything else that supports the issue that he was a supervisor when he was terminated. And the lower court did find that it was a material issue of fact of whether or not he was a supervisor when he was terminated. And it's my opinion that if the jury found that he was not a supervisor, the jury can also then find that the reason for letting him go was a pretext for age discrimination. And that becomes into real focus when you take into account, in the lower court, he did not even mention that he asked, Mr. Johnson asked to be part-time, and just weeks afterwards, Statewide went out. I mean, the request was rejected, and just weeks afterwards, Statewide hired a number of part-time security guards, years and years and years younger than Mr. Johnson, at the very same location.
Mr. Gomberg, did Statewide ever articulate any other reason to Mr. Gomberg, to Mr. Johnson, as to why they were terminating him, other than the fact that they were eliminating the supervisor position?
Not that I'm aware of, Your Honor, no. That's what they said, they were eliminating it. That's the material issue of fact, because he was already demoted. He clearly was not a supervisor, and that's the disputed material issue of fact that hangs over the case when he was terminated.
And as I understand it, that there was no assertion that Statewide, for example, was getting rid of the supervisory position for financial reasons or anything related to payroll or anything like that.
Not that I'm aware of, Your Honor. I know there may have been a change in the relationship. To be fair, there may have been a change in the way the structure at the school where he was a security guard, but that had nothing to do with Mr. Johnson, in the sense that they still went ahead and hired people to take over that position, doing the same duties and doing the same location, sitting at the same desk that Mr. Johnson was. And they always said Johnson was doing a good job. It was never a performance issue. In fact, they said there was no performance issue. So they just got rid of an older worker, is really what it amounts to, a much older worker. I guess I better save my rebuttal time.
That's fine.
Thank you, Your Honors.
Thank you. Ms. Mathias?
May it please the court, good morning, and thank you for taking time to hear from us today. My name is Megan Mathias. I represent Statewide Investigative Services in this matter. As you know, the judgment was entered in this case on September 19th, 2022. The trial court in the judgment identifies the correct burden shifting framework under McDonnell Douglas. The initial burden is on the plaintiff to identify similarly situated employees who are not members of the protected class and treated more favorably. Plaintiff does not meet his burden. He cannot identify such persons outside the class that were treated more favorably.
Ms. Matisse, but we
Yes.
also, under Ortiz, have to look at the totality of the circumstances, right?
Yes.
And to see if there's a factual dispute that might necessitate a trial. If I could ask you the same question I asked Mr. Gomberg, did Statewide articulate any other reason for terminating Mr. Johnson other than the fact that they were going to eliminate the supervisor position because they did not feel the position was necessary?
No, and in fact, they said the position was being eliminated, and what I would like to talk about a little bit, if I have the time, is how in the response that's the document 88, it's not a verified response to the statement of fact. Some of those admissions should be deemed admitted because the response to the statement of fact does not include a verification, and therefore some of the very critical facts are actually fatal to the plaintiff's case.
But I guess what I'm trying to get at, and perhaps inartfully, is that, for example, Statewide never told Mr. Johnson that they wanted to get rid of all full-time positions because they wanted to go all part-time because of financial reasons, or that they thought that that the work didn't require anyone to be there full-time, and they wanted to hire everyone on a part-time basis. They didn't articulate any sort of reason like that. Is that correct?
Mr. Baroni did testify in his deposition about how why he didn't believe there was a need for the supervisor position at the location. Mr. Johnson was the only one that worked full-time and had the supervisory role. For example, there's some discussion about when there's a bomb threat that's in the statement of facts, that the employees were instructed to go to Mr. Johnson. There had been basically so many years with no events that they decided that they didn't need the full-time supervisory position.
But it wasn't because of financial need. Is that correct? So, for example, I think Mr. Barone testified that it wasn't because it was financially
Right.
driven. It was just they didn't think that they needed the position with basically with the supervisor duties at that location.
Right.
We've also slipped between full-time and supervisory, and those are technically different concepts, correct?
Correct. Theoretically, at Statewide, the supervisors were full-time, but theoretically, you could still have, in general, in the industry, a supervisor that was part-time. But at Statewide, there were 2 client locations, and it's in the record, where there were supervisors, and one of them was the Campbell client location, which is where Mr. Johnson worked throughout his employment, and it was a full-time position.
Is it possible for one full-time employee working 40 hours a week to be replaced by 3 part-time employees of a younger age, and that be discriminatory?
Yes, I think the issue here is that they didn't, what Mr. Baroni testified to was, like in the police department, because these are mostly all retired or some of them current police officers, once you're a boss or a chief, it's hard to go back to being a patrolman because then there's this dynamic that's difficult. And so Mr. Baroni testified about how that would be perceived by the rest of the staff and probably not welcomed. But yes, theoretically, I guess if you're only talking about the security guard duties, of which a supervisor also includes that in their job, then you could do that. But a supervisor here has more responsibilities. And again, that wasn't properly denied. If you look at the response that was filed in its document 88 in the underlying record, a number of the paragraphs have a denial in the response, but because it's not verified pursuant to local rule 56.1, those are deemed admitted. And those are critical facts here.
Can you point me to the paragraphs that you're talking about?
Sure, let me go through in detail. It's essentially all of them, but because of the way it's written. The response to paragraph 3. Plaintiff denies that only supervisors wear white shirts, etc. That fact is not supported with a verification or a declaration, anything like that, and would be deemed admitted. It's not controverted with specific cites to the record. For example, paragraph 4, similar issue. It cites the declaration, paragraph 12, but if you look at the declaration in paragraph 12, it doesn't stand for what it says it stands for in the response brief. Paragraph 5, paragraph 8, paragraph 10, 11, 12, 14, 20, 22, 23, all have the same issue, a denial without a controverted fact. What I think is actually fatal to the claim is paragraph 26 of the response brief. While he has a page, probably a little more than a page, of citations to other things in the record, the first sentence of the response is a plain denial, again, but it's not supported by the declaration, it's not supported by cites to the record. And in fact, there's nothing in the declaration relating to these particular facts. And I'll just read the fact. The position of supervisor was eliminated at the Campbell client location as of February 4th, 2019, because it was no longer needed. Harold was not terminated because of his age. There was still no supervisor at the Campbell client location. Again, his initial denial is just that plaintiff's position was eliminated at the time of his discharge. But again, that's not properly rebutted under the local rules and therefore should be deemed admitted. If that's true, then I think not all of these were picked up by the trial court. Some of them were, including the unrebutted payroll reports that Your Honor mentioned with respect to my opponent. But not all of these admissions were picked up by the trial court. But I think here, given the de novo review, you could look at that and say he's now deemed that to be admitted, and therefore he can't meet his burden under any analysis, including Ortiz.
So there are documentary records in the company's payroll system reflecting
Yes.
his status as a supervisor at the time of his termination.
Correct. And in our motion for summary judgment, we attached an affidavit which attaches the documents, and there's payroll records for Mr. Johnson under the payroll records, and the trial court judgment picked it up as well. She references unrefuted payroll reports and it has an S: Super V, like supervisor, in the payroll reports. Again, those weren't rebutted in any fashion and were part of the record.
So he's classified for pay purposes as a supervisor. He's also full-time. And he was hired as a supervisor, so
Correct.
that never changed throughout his employment.
Right, and some of the, even in the deposition testimony, well, even though his counsel instructed him not to answer some of the questions relating to this particular issue, which I find interesting that they now say they can't or couldn't, for some reason, update their discovery before discovery closed. In his questioning, he talks for quite some time about what happened the day he was fired. And it's ironic that he talks about his wife was there and Mr. Baroni spoke to his wife or spouse, and that these were the questions asked. And I asked him anything else probably 5 times in the deposition transcript for this exact reason, because there was nothing else said. But his declaration, which was properly pointed out as being the sham affidavit rule was properly applied in my opinion, now says all of a sudden after the close of discovery that including up into February 4th, 2019, that Mike Baroni called me an old man. So to say that all of a sudden on the day of firing he was called an old man and not disclose that fact until obviously we had filed our motion for summary judgment almost 18 months after the close of discovery, I think is the whole reason the sham affidavit rule exists, so people don't just create facts to get past the summary judgment motion. If I would...
Right, we are familiar with the reasons for the sham
Yeah.
affidavit rule, but the district court did not explain, the judge didn't explain in her decision what she was applying the sham affidavit rule to.
Well, I
She
believe
just
that-
says she's applying the sham affidavit rule to certain averments which she will disregard in Johnson's March 2022 declaration
I think
that
those are
contradict his December 2020 deposition testimony. So without rummaging around in the record, we're not going to know what was in the district judge's head about what she was disregarding.
Well, there are two paragraphs in particular, paragraph 7.1 and paragraph 9, that contradict what his deposition testimony was.
Okay, so we're going to find all this in your briefing in the district court about what
In
was
the
actually
district court.
disregarded, what you asked the judge to disregard.
Um,
I'm trying to figure out what the judge disregarded.
yes,
Did
I
she
understand.
disregard just some of the so-called ageist statements, or did she disregard something about his status as a supervisor? Did she disregard something about what he was told about why he was being fired? What is it that the district
Correct.
judge excluded under the sham affidavit rule? Or maybe we should just set that whole issue aside,
I think the only real
since she didn't explain.
two pertinent facts in the declaration that are new and different, that are different from his deposition is paragraph 7.1, which talks about at the time of termination, him saying, "Oh, I asked him if I could go part-time." Because in his deposition, he doesn't say that after many of my questions, anything else said during that call.
Okay, that's an important fact.
Correct. And also paragraph 9 of the declaration, where he says, Mike Brony called me old man several times now from 2017 through the date of firing, which is a new fact. And of course, that was not stated in the deck anywhere in discovery ever.
Okay, so his declaration placed approximate, or identified approximate ageist comment, or approximate to the firing. The other problem was that the others were distant from the firing.
Correct. This was the first time he'd ever said it happened through and including his termination date.
So
But-
introduced two facts, disputed facts, that were not discussed at the deposition, that were consequential to the legal issues in the case.
Yes, Your Honor.
Okay.
After we raised that there was no contemporaneous act, that's when now there's an allegation that there was.
So by piecing together what you were challenging under the sham affidavit rule and what the record shows, we'll be able to infer what the district judge had in her mind when she applied the sham affidavit rule.
Well, I think the most of what's in the declaration is actually not, a lot of it is an argument of why he didn't produce information, so there's really not that many actual facts in the declaration. So
Okay.
I think I'm out of town.
Yes.
Could I follow up
Oh,
on your
please.
question, Chief Judge? On page 41 of his deposition transcript, he does say, and on several occasions, after he talks about the September 17th occasion at the restaurant, he does say, and on several occasions he referred to me as an old man. How is that inconsistent with his declaration?
Because we had asked him when and where and what happened, and he described these two lunches in 2017.
Right, and then he says, and on several occasions he referred to me as an old man, but there isn't any follow-up on what those other occasions were.
Well, we're only then a couple of pages from when, in my opinion, counsel had instructed his client not to answer, answered his phone, asked his assistant for water, was talking to the witness when he was testifying, told the witness don't guess, like was interfering with the questioning so much that I terminated the deposition, but we were getting into that line of questioning. But again, I don't think, it's not my duty to disclose the facts. I think it's his burden, and discovery was still open. We took, I think, I won't say the wrong number, but I want to say 7 or 8 depositions after this deposition of lots of people. There was no statement that he's ever provided from his wife, for example, who was on the call when he was terminated to say that he was called an old man. There's been nothing other than a vague reference, and I did ask him what all the bases were for his belief in the deposition for why he was terminated for an age-based reason, and he didn't give me that, and I did ask many follow-ups on that piece.
Thank you.
Thank you.
Thank you
for your time.
All right, Mr. Gomberg, you had a little bit of time left for rebuttal.
Thank you, Your Honor. Just to address some of what was just discussed. Again, Judge Coleman said that being the supervisor, whether or not Mr. Johnson was a supervisor, was a material issue of fact.
We don't have to
Yeah.
accept that. This is de novo review.
Okay, well, I'm just saying that she didn't, I'm not aware of any reference to the fact that there were pay records that indicated,
It's in,
then-
it's in the decision. And it's in the record.
okay, I didn't see it in the decision, but, okay. Also, I just want to reiterate that, Mr. Johnson we didn't get to finish the deposition. I'm not aware of anything in the court's opinion that specifically indicated what statements in the declaration would be considered to be stricken. And I'm not aware of anything that says that Mr. Johnson in the declaration says that he said that he was asking for a part-time job at the time of termination. So that, I believe, is in contrary to what our counsel just said. Again, this is something that counsel didn't bring up. Some of the things that she was talking about a verification of statements. I've, quite frankly, never heard that before. I don't see it in any briefs. So I'm not even really aware of what counsel was referring to in that regard. So we hope that this court would give us an opportunity to present this matter to a jury. Thank you very much.
Thank you very much. Our thanks to both counsel, all counsel. The case is taken under advisement. And we'll move to our second case this morning, Christian Arnold versus Kololo Kijakazi. And I believe both counsel for this case are online. All right, I see Mr. Jones and Ms. Milano. Can you hear me?
I can hear you. Can you hear me okay, Your Honor?
Yes. All right, Mr. Jones, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. Daniel Jones. I'm appearing on behalf of the true party in interest in this case, which is the law office of Binder and Binder. In this case, we'd like to thank the court for hearing oral argument on this case. It's extremely important, not just to the Social Security bar, obviously, for being able to request appropriate attorney fees, but also we think to claimants to be able to get effective and efficient representation, and that the fees are protected so that they're reasonable in these types of cases. As the court below found, counsel's fee was too high, awarding only $16,920 out of the requested fee, reducing it by 58%. We believe that the court started with the wrong position in this case. Although the district judge mentions this case didn't present any particularly difficult challenges or extraordinary circumstances on pages 91 of the appendix, she then goes on to note that other cases in the context of Second Amendment have awarded effective hourly rates of $300 to $600 and then sets the hourly rate here at $600. So it's apparent that the district court is actually starting with the lodestar amount. Those cases are not even applicable in any way to the facts here because those cases award fees under a lodestar amount and they're awarded under fee shifting statutes. Here, that's not the case. This is a contingency case and it's not fee shifting.
Mr. Jones, if we agree with you, Mr. Jones, on this distinguishment with regard to the fee shifting point, you're asking us to adopt the Second Circuit's approach in Fields. There's also alternative approaches from the Sixth and the Ninth. Specifically, the Sixth talks about contingency fee being a rebuttable presumption. It somewhat resembles the Fifth Circuit standard, but not identical. Are you asking us, if we address this area, to adopt the Second Circuit's position, the Sixth Circuit's position, or a different position?
Yeah, I think the Second Circuit's position is the one that best encapsulates what has happened with the law since Gisbrecht.
So you would have us leave behind the rebuttable presumption of the contingency fee?
Well, I think there is a presumption that of starting with the contingency fee, And I think that the Second Circuit's decision started with that as well. But the Sixth Circuit has taken the position that that the court should start with a floor and then can multiply a particular hourly rate to come up with something reasonable. I don't believe that that's appropriate post-Gisbrecht. I think that the Second Circuit's four-factor analysis better encapsulates a proper determination of windfall. And I think it's a little bit confusing. I agree with some of the frustration that Justice Scalia expressed in the dissent in Gisbrecht of how the courts are supposed to apply this sort of hybrid analysis of beginning with the contingency fee, but also in some cases looking at hourly rates. And I think that the best way to apply it is what the Second Circuit did in Fields, and making an initial determination, is there a windfall? And if there is a windfall, then considering hourly rates just as one factor. But here, the court starts clearly with the lodestar amount. And even if we get into the factors, the court made clear that where it did consider the Fields factors, none of them weighed against awarding the full fee, except for this one about whether the case was risky or not. And the court did not explain why it found this case was not risky. It didn't tie a reduction of 58% of the fee to any particular finding. And I think the court is just wrong on that point. I think it's a false premise to say the case.
If I could interrupt, because time
Sure.
is short. Before we get too deep into the district judge's rationale here, and I read it more holistically than you do. She did touch on all the factors that were mentioned in Gisbrecht as being potentially relevant. My question is really antecedent to that, and it is about the nature of the contract in this case, the retention agreement, and whether it's really a true contingency agreement at all. It obviously is, no fee unless we win kind of contingency. And that's necessary in this context because of the statutory structure for payment of fees. It comes out of the recovery of past due benefits, if there is such a recovery. But it doesn't, as I read the agreement, and perhaps I'm misreading it, but it says the law firm may apply for fees under 406A and 406B, and the combined amount of these fees will not exceed 25% of any back due benefits. That's not a promise. That's not a promise on the part of your client to pay a 25% contingency. It's an agreement that acknowledges your firm's entitlement to apply for fees under the statute, as long as they don't exceed 25%. So there's no agreement to pay 25% of all past due benefits here. And so are we really starting from the same starting point as the Gisbrecht case and the Gisbrecht line of cases, given the language of this retention agreement?
Right, Your Honor. Well, all agreements contain similar language in my experience, and that's because the district court has to approve any fee. So can never be a case where the parties stipulate to fees under 406B. It's not like
I'm not
equal access
suggesting
to
a
justice.
stipulation. I'm focusing on the language of Gisbrecht itself, and the agreement in question there was an agreement that each client would pay counsel 25% of all past due benefits. That's just a restatement of what how the Supreme Court described the agreement in question in that case. It was a true contingency agreement, and most contingency agreements in other contexts are stated in those terms. But your agreement simply restates the statutory language, which permits counsel to apply for fees and the court to award fees in a reasonable amount not to exceed 25%. So why should we be giving primacy to a 25% award as you're requesting us to, because your agreement doesn't even say that.
Well, the agreement says that we may petition the court for up to 25% of the fees, and I don't think that this is an issue that was raised in the district court or that's even before the court. We haven't briefed to this issue, and the district court didn't decide it. But
Well, we do have
I
to
don't-
apply the contract language, because the whole
Right.
point here is that the contract is entitled to significant weight in this context under the statute. That's the takeaway from Gisbrick, that we shouldn't ignore the contract and apply lodestar as we do in fee shifting statutes. We should pay attention to what the contract says, and if the contract privileges a 25% award, that's also deserving of weight, subject to a lot of other factors.
right.
And there's
Well, I
a
think that the-
disagreement among the circuits about how to weigh all of those other factors and when those other factors should displace the 25% agreement. But there wasn't a 25% agreement in this case, is my point.
There was an agreement that the claimant would pay up to 25% upon approval by the court.
But that's not an agreement to pay 25%. It's just, you've restated the statutory language in this agreement. You've said, we're going to apply for fees under 406A and 406B, and the combined amount of these fees will not exceed 25%. And when your client signed that, there was no agreement to pay a presumptive 25%. It was an understanding that you would apply for fees, and the court would set fees not to exceed 25%.
Right.
So why are we even
I don't-
Gisbricked at all?
I don't think that that's inconsistent with Gisbrecht or this court's holding in McGuire about fee agreements on a contingency basis. I don't see the conflicts there.
Okay. Anything else?
I did want to save some time for rebuttal, but I had some other points to make. If the court has questions, I answer now, or
I'll give you some extra time.
thank you.
Obviously weren't anticipating this line of questioning, so I'll give you some extra time at the back end. Okay, thank you. Ms. Milano?
Good morning, Your Honors. Good morning, Counsel. May it please the Court. My name is Jessica Milano. I'm appearing on behalf of the Acting Commissioner of Social Security. This case involves a fee petition under 406B, and Congress has set forth pretty stringent requirements, given that these are coming out of a claimant's past due benefits. In this case, the district court identified the accurate legal standards and reasonably applied the factors in her consideration of the fee request. For that reason, the court should defer to the district court's decision. Her findings were not clearly erroneous, and a reasonable person could definitely agree with them under the facts here.
Ms. Milano, do you want to address this idea that the district judge was analogizing to Second Amendment cases and was referencing fee shifting statutes, which might differ in operation than Section 406?
Yes, I believe it is relevant because there's a couple of reasons I think that case was relevant, although it was a fee shifting statute. The court was looking for a case that was within the same regional area, so the same market, and also involved similar risk and involved counsel of similar experience. So I believe at the end of the day, it was not improper for the court to look there. And the court also considered Social Security cases within the same region as well. So I think it was one of many considerations, but I think it was a litmus for finding what is a rate that would suffice to attract counsel of the same experience for the same type of risk.
I have to think that the number of Social Security cases greatly outdistance the number of Second Amendment cases.
That is true. I would agree with that. And
So putting to the
I
side
think-
the contingency fee question, whether there was a contingency fee arrangement here or not, the point of the contingency fee argument, I suppose, is all of those times when the plaintiff's counsel might take the case but be unsuccessful, those have to be offset by successful cases. And that there's a certain built-in risk that a plaintiff's counsel is taken by operating in this area of the law. If that's what the district judge was going for, query whether we need further elaboration. I mean, I see the 300 to 600 range, and we all as lawyers kind of have a feel for an hourly range on many cases, but that can collapse, that can dissipate in certain areas, in plaintiffs' areas. Was she just using the 300 to 600 and then analogizing to people in that regional area, or what's her reasoning here?
Your Honor, I don't think she was relying solely upon that. If you, at the outset of her decision, she explains she agrees that she shouldn't start with the lodestar, and then she methodically goes through each of the factors. Many of the factors weighed in counsel's favor. The court was very appreciative of his experience and efficiency. At the end of the day, the problem was that it was just a very small amount of time, and it became a very large amount of benefits that were going to be paid out. So it just tipped the scale. The district court's in a hard position in that, again, some of those factors did weigh in favor, and some, ultimately, it fell the other way. As far as the risk analysis, that's generally a case-by-case consideration. So while there is inherent risk, courts will consider whether this was a more risky case than another case. But again, here I don't think the district court relied heavily on risk. I think it relied heavily on the fact that it was a very moderate-sized record, and there was no reply briefing required and no oral argument, so it didn't require as much time input.
Ms. Milano, I think perhaps if the district court had articulated the way you're articulating now, that might have gone a long way. But the district court seemed to, when looking for kind of extraordinary factors,
Right.
what that suggested to me was the district court was starting at the baseline of the hourly rate, that is the lodestar rate, and then trying to see, okay, well, what makes this case particularly difficult so that I could justify awarding the fee pursuant to the contingency agreement, assuming that an enforceable one exists. That to me seems the opposite of what the Supreme Court required in Grisbrecht, right? I mean, if we are to give primacy to the contingency agreement, it seems to me that whether we call it, presumption, whether we call it deference, whatever we might call it, that should be the starting point, and then the district court should perhaps augment the analysis to see whether or not that starting point is a reasonable one, as opposed to starting at a lower point and trying to justify going higher. That seems to be two distinct approaches.
Sure, Your Honor. I think that if there's no set methodology, and that's the problem, right, is Grisbrecht doesn't explain how a court should go about that. Should the court be reducing? Should the court be... And I think multiple courts have approved multiple ways of calculating this. Here, I think that the district court judge was within the realm of her discretion. I understand what you're mentioning about the extraordinary circumstances, and again, I think that was one of the many factors. And I think she was looking at the case as a whole and trying to met that out. And the other problem is inherent in when you have a case where not as much time was expended because there was a voluntary remand, or the briefing just didn't require as much time. It's hard to not come to that and say, wow, this was a lot of fees based upon the time spent. So
But
it's unfortunately.
Ms. Milano, though, if I could push back a little bit,
Sure.
couldn't it also be an indication that the law firm has a particular expertise in the area, so doesn't have to do all the basic research that a general practitioner might have to do, and because the law firm is so active in this area, that the reputation of the law firm is well known to the commissioner, and so that might factor into all those decisions. And so it seems
100%.
it seems like to some extent you might be punishing the law firm for its expertise and efficiency, but by saying, look, they were too fast and too good, so they don't deserve anything more than the lodestar amount.
Right. I think the district court did acknowledge and appreciated the efficiency and expertise. So I agree that is a factor that weighs in counsel's favor here. And the court came down ultimately and found the tipping point was elsewhere. Your Honors, the commissioner believes that the district court was within her discretion, and that the court should defer given the district court's consideration of the fact-specific matters of the case, given that these are decided on a case-by-case basis. Unless the court has any further questions, I'll rest on our
Ms.
briefing.
Milano, what's your reading of this language in the contingency agreement, the retention agreement? Is it
Your Honor,
a true contingency agreement, other than in the sense that the fees are going to come out of the recovery, which is the first criteria for a contingency agreement? It's not an hourly based fee agreement. It's a contingency agreement, in that the fees will come out of the recovery up to 25%.
I do read it as a contingency agreement. The first sentence of the first paragraph: if the appeal is successful and I'm awarded past due benefits by federal district court or circuit court, the law firm is to receive up to 25%. So I do read it that way, and to the extent that
that's
it
actually
is
not what it
nuanced,
says, and I'm not questioning that it's a contingency agreement in the sense of recovery coming out of past due benefits awarded. I'm asking whether it's a promise to pay 25%, presumptively, subject to the court's reduction of that amount pursuant to the statute.
Your Honor, I read it as an agreement to pay what is approved by the agency, and what 406A fees are required to be approved by the agency, and 406B fees are required to be approved by the district court. So my reading of this and similar contracts is that I'm agreeing that if the court approves this, I will pay it.
Meaning that 25% is the presumptive recovery, and we're to privilege that amount under Gisbrecht and the cases subject to reduction? Or
Right.
that it's just a reasonable fee up to 25%, whatever the court approves?
I think, right. And I think
Those are two
that-
different things. Those are two very different things.
You're right. No, you're right. And this leaves, the wording of this contract certainly leaves discretion to the firm to not request the full 25%. I don't think there's a presumption that, based upon the wording of this contract, that the firm would always request 25%. So
Well-
I see where you're,
Right. But in the real world, where everybody lives,
right.
under this contract, the request is always going to be for the 25% if there's an award of past due benefits made. And the question is whether that gets some presumptive weight under the language of the contract and the case law. Yes or no? Or does the judge just assess a reasonable fee within the 25% limit because that's what the client agreed to pay? Only some number up to and including the 25% limit, not 25% presumptively, subject to reduction.
Your Honor, if as counsel mentioned, this wasn't an issue briefed, and if the court is interested in this issue, we'd certainly be happy to brief it. I understand what you're seeing.
That's fine. We'll let you know.
Thank you.
Okay. Mr. Jones, you can have an additional 3 minutes in rebuttal because you didn't get to make all the points that you wanted to make, and this is an important case for your firm and for the Social Security bar.
Thank you, Your Honor. Just to touch once more on what you were just discussing with opposing counsel, I'd like to point out that in the real world, we actually don't request 25% on every case. There are cases where we self-reduce our fees because we do believe it's a windfall and it'd be unfair to the claimant. And I think those cases are important to take note of. And I think that those types of cases we're actually taking note of in the consolidated cases in McGuire that was before this court. Two of the cases that were part of that case were sent back because of a concern there was a windfall. And those were because in one of the cases, the attorney had only spent 3.24 hours and the other one 5.6 hours. And these are the types of cases that I think are actually a windfall. And in those cases, we never request the full 25%. Those are often cases that are remanded without any briefing done at all. So it's becoming actually more frequent that the commissioner will either before the answer is filed or right after the answer is filed, will review the case and decide this is not a case we're going to defend. And they'll agree to remand the case without any briefing. And in those cases, I do think it would be appropriate to find a windfall if an attorney was to request for the full 25%. And I think it goes to a phrase that's used in Fields and some of the other cases as well, of whether the attorneys enjoy an unearned advantage. And certainly that's the case when a case is sent back without any briefing by the attorney. Or in the McGuire case, the cases were sent back because there was a change in the law. At that time, Congress had passed the change in the law that mandated sending those cases back. So the risk factor became much less than it was. Whereas this case, we appealed the case at a time where this court had not issued any comprehensive decisions on how to interpret the commissioner's new regulations for evaluating medical opinions. And I think the risk factor has to be assessed at the time the appeal is undertaken. Justice Scalia says, even in his dissent, we're not going to make ex post facto evaluations of the riskiness of the case. Even to this date, this court hasn't really done a detailed analysis of how medical opinions are evaluated under these new regulations. And certainly at the time this case was appealed. And to relate this case to the Fields case, the court here didn't find any of the Fields factors warranted reducing the fee other than risk. And Fields was adjudicated under the treating physician rule with decades of case law at hand to interpret, versus this case, which was much more risky under the new regulations.
So I take that to be a suggestion that we'd be creating a circuit split with Fields if we come out differently here or apply a different methodology?
I don't think that there would be if you were to apply a different method than Fields.
Well, you're encouraging us to, because our circuit hasn't weighed in on this fees issue since before Gisbrecht. And so you're
Correct.
encouraging us to follow the approach of the Fields case, which is the Second Circuit, instead of the Sixth and Fifth Circuit's approach.
Well, I don't even think that Fields is inconsistent with the approach in the Fifth Circuit in Jeter or the Sixth Circuit in Lastly, I believe is the name of the case, because all of the cases say that when undertaking a windfall analysis, that the court should consider multiple factors. Here, the court found the risk factor controlling over all other factors.
Okay. All right. Anything else?
If there's no further questions, Your Honor, I would ask this court that it should reverse the case as was done in Fields and in Crawford, just because the Supreme Court said that these cases should not result in satellite litigation that goes on and on forever, but at the very least that the case should be remanded with detailed instructions to the district court on applying the correct factors and explaining the decision.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement, and we'll move to our third case this morning, Alvaro Bonilla versus Garland. Mr. Schrank, whenever you're ready, you can come on up.
May it please the court, my name is Ray Schrank, and I had the privilege of representing the appellant both in the immigration court, before the BIA, and now before you. You are presented with a very significant particular social group issue in this case, and that relates to whether or not the Seventh Circuit is going to change its long line of decisions saying that socially distinct and particularity are required to define a particular social group. In this case, the particular social group was the widow of a hitman in Honduras. The judge, the immigration judge, found this to be immutable, that she can't change and should not change that condition of being the widow of a hitman. However, both the immigration judge and the Board of Immigration Appeals required that in addition to showing it was immutable, she had to show that she was socially distinct and that she had particularity. This court, in a long line of cases starting in 2009 in Gatimi versus Holder, held that social visibility or social distinction are not required. And the reason is relatively obvious if we think about it. First of all, people who are at harm in a country do not want to be recognized. They aren't socially distinct, they socially hide. Secondly, in some of the most significant cases this court has addressed, including female genital mutilation, this court held you can't identify by looking at the person what their social distinction is. Just like in Denaya Alvaro's case, you can't look at her and see that she's the widow of a hitman. Now, she came to the United States with her minor son in 2014 to escape the abuse of her husband, Johnny Matut Majango. Okay, he was very abusive to her, which is set forth in the record. And that abuse, of course, ended when he was assassinated with a bullet to the back of his head in 2016. In between that time, he had come to the United States to get his wife to go back to Honduras with him. However, he was deported and therefore unable to take her with him, and she remains in the United States. Once Johnny Matut Majango was assassinated, her particular social group changed as the future harm.
If I could interrupt for a moment.
Sure.
You spent most of your argument in the brief and now so far in oral argument focusing on this question of the cognizability of the particular social group as it has evolved throughout the course of this litigation. But the primary reason that your client's claim was rejected is that it was on the antecedent question about whether she had suffered past persecution, setting aside the reason for that, whether it was because she belonged to a particular social group that is cognizable, the board concluded that she hadn't suffered past persecution.
Right.
And so that's where the focus should begin.
Maybe I can clarify a little bit. Okay. The appellant never gave up the fact that she was a domestic violence victim. What she gave up, and what is clear in the immigration judge's decision in footnote 2 on the second page, is that what the appellant gave up was the fact that domestic violence can no longer be a nexus to future harm, because the future harm cannot occur from her abusive husband because he's dead. So you are correct that both the immigration judge and the BIA said there's not past harm, but they avoided addressing two obvious things. Number one, that she was a domestic violence victim, and number two, that what had happened to her husband while he was alive in Honduras also is harm that were reflected to her. There is a nuclear family here, and she has never changed the fact that she was married to this person up through his death. What happened to him was he was shot in the arm and it was immobilized. He had people pointing guns at their house, including her, and approaching the house. He also ran a motorcycle off the road on the claim that somehow this person was going to harm him and his family, and the appellant was in that car. He warned the appellant extensively not to go out by herself because she would be at risk because he had many enemies. And finally, the ultimate of harm was when he was assassinated with a bullet to his head. There can be no question that her husband suffered harm, yet the immigration judge and the BIA did not consider that in considering harm to this widow. And yet that is a very significant factor in the cases out of the Seventh Circuit, saying you can look at family unit for purposes of identifying harm. So you are correct, Judge, that they did not find this, but I find that their finding is not accurate on the facts of this case. Domestic violence alone, this court has held, is
Well, the domestic violence component of this drops out because
the
her
domestic violence
husband-
component of future harm dropped out because it could not happen. The domestic violence itself was never given up. In fact, there was testimony allowed by the immigration judge about the domestic violence at the time of the hearing. Domestic violence never left this case. It left this case as a nexus to future harm.
Well,
So-
that's the whole point of the presumption that attaches to past persecution. If the past persecution was domestic violence and that threat has ceased, then it just drops out of the case. So
With the
let's focus
exception-
on
with
the harm that is supposedly gang related, because that's
The risk of future harm is yes, I agree.
and what is there any evidence? What is the evidence? And there's discussion of this in both the IJ's opinion and the board's opinion about the gang-related harm to her.
There is evidence supporting the gang-related events, okay? The appellant relied upon Professor Lirio Gutierrez Rivera as a country conditions woman's expert in Honduras. She provided opinions, and the court accepted her opinions as she was an expert. She testified unequivocally that this person, Denaya Alvaro, was at great risk of future harm because of gang involvement. Then a question came up, well, did the appellant say that he was a member of a gang or not? And she was asked a question by the immigration judge in which she answered, saying, if he was not a member of a gang, the threat to Denaya Alvaro Bonilla will continue if there was any gang-related enemies that he had. And that's basically where this case is. He was a hitman. He had many enemies. They were going after him. And in Honduras, they don't just go after the person who hurt them, they go after the person's family. Again, in the testimony and supported by the evidence.
So, counsel, the testimony by the claimant, Ms. Bonilla, I thought she said she didn't know whether or not, she personally did not know whether or not her husband was part of a gang.
That is correct.
Or
She did say that.
or that her husband was a hitman, right? And I think the information about that came from Ms. Sonia, one of her friends.
While she was living in Honduras with her husband, she did not know he was a hitman. She found that out from a friend after she was in the United States. You are correct. And secondly, you are correct that she did not say, she didn't say he wasn't a member of the gang. What she said was, I do not know if he was a member of the gang. Again, going to her credibility, because it would have been very easy for her to say, yes, he was, and the whole argument would be different, but she didn't say that. And so what she did in telling the truth is she created this issue about whether he was a member of a gang or not. Professor Gutierrez Rivera took care of that by saying whether or not he was a member of a gang is not as significant as whether or not gang members were after him, because it's the gang member contact and going after him for harming one of their own that creates this risk of future harm for his wife or widow. I do want to save some time for rebuttal.
That's fine. Thank you. Ms. Bird.
May it please the court, Sarah Bird on behalf of the respondent, the Attorney General. The court should deny this petition for review on either of two paths or grounds. The first seems to have been the focus of the questions. There was not a showing of past persecution, and there's no well-founded fear of future persecution. The second is the cognizability of the particular social group, which I think I agree with opposing counsel, is a very important issue before this court. And this case presents an opportunity to clarify the law and defer to the agency's decisions. But I'm happy to address either, whatever there are questions about. I'll start with the past persecution. Because the domestic violence claim was withdrawn, while I agree that it's still part of her experience, it was no longer part of her claim. And so she couldn't, her abuser, the reason she fled Honduras was his abuse, and he was now dead. So she didn't fear returning because of that anymore. So as a strategic matter, she withdrew that claim and proceeded on a new claim representing why she now fears returning. And so the domestic violence isn't part of the past persecution. There are some vague threats that she experienced related to her husband's enemies that just don't rise to the level under this court's case law of past persecution. In general, threats go to a future fear rather than being enough in and of themselves to be past persecution. So the agency reasonably, and substantial evidence supports it, found that there was not past persecution. As to well-founded fear, she no longer gets a presumption because she didn't show past persecution, so that's her burden. And here, the agency found that it was speculative, and also that she could reasonably relocate. She can't show a well-founded fear if she can reasonably relocate. She did not administratively exhaust the reasonable relocation finding. She didn't challenge it, and the board said it was undisputed, so the board found that there was no challenge to it, it's undisputed, and didn't get into it. And so it was also waived in the opening brief. So as to well-founded fear, that issue, the relocation issue, which is dispositive of whether or not she can meet that burden, isn't properly before this court. Turning to the particular social group, if there are no questions about that, one possible ground for denial. Particular social group, the board held in 2014 in response to this court's line of cases that counsel mentioned, that social visibility does not require ocular visibility. It doesn't require that you be able to see and recognize someone, but instead it has always been intended to point to social distinction. And in 2014, the board renamed it and clarified and addressed this court's, and the Third Circuit had also disagreed, addressed those concerns in two decisions, published precedent board decisions, and every other circuit of appeals has deferred to those cases. This court has said in multiple cases now that it's still an open question. And the fact that it's an open question is significant because it appears that there may be some confusion for applicants. When it's an open question, the board is going to apply their precedent. MEVG and WGR apply because it's an open question in this court, but some applicants seem to think that they only have to show immutability. So for that reason, and because the board's decision is reasonable, this court should take advantage of this opportunity in this case and defer to the board's interpretation in MEVG and WGR.
Don't we have some opinions citing those cases?
Absolutely, but not very many, actually. I found
so
about
CC and
4.
Torres are still causing problems?
CC and those cases were before. Right.
I understand. That's what you're asking us to fix,
Yes.
is what I'm getting
Yes, absolutely, Your Honor. And there are very few published Seventh Circuit decisions, or even unpublished ones, citing MEVG and WGR. I've found a few, but none of them turn on particularity or social distinction. For example, in Melnick in 2018, this court has kind of a history of it, cites, acknowledges CC and those concerns, cites the board's efforts at clarification, and then says, we have not had the occasion to consider this effort, and we need not do so today. Because in that case, the board didn't rely on social visibility or particularity. So it wasn't before the court. And similarly, in WGA, the court declined to reach the question that the court acknowledged some concerns, and we addressed those concerns in our brief, but again, said that it's an open question. So this court has not yet deferred. This is the only outlier circuit that hasn't yet deferred to MEVG and WGR. I also, as I was looking at this, noticed that in CC, the court starts its whole analysis of the particular social group by saying we must first ascertain the parameters or contours of the group. So although the court was not agreeing with the board on particularity, the court was actually kind of applying it, because parameters and contours of the group is what particularity goes to. It's the boundaries of the group. And similarly, this court in Ramos said that while the court has not deferred to social distinction yet, the court talks about how veterans are not socially visible, but they are a socially salient category. And that's social distinction right there, that they're recognized in society as a category even though they are not visibly identifiable. So this court's case law, even prior to MEVG and WGR, seems to have considered this somewhat, and then the board clarified and has shown that these are reasonable clarifications because they are in line with some of this court's case law and how this court was approaching it. And they're entitled to deference even if they're not the best.
As long as Chevron lives.
Well, true, true. But I do have an answer to that, Your Honor.
Oh, good.
Well, not
Enlighten
the
us.
actual answer. We'll see what happens with that. But it does seem possible that that case will be decided on Chevron Step 1 or will mainly affect Chevron Step 1, whereas particular social group has always gone to Chevron Step 2 because it's so ambiguous. So we'll see what happens with Chevron, but at the very least, even if Chevron is totally upended, this court would be in the same place as every other court instead of being the outlier who hasn't yet deferred.
And MEVG and WGR, so many case names with acronyms or
Yes.
initials. Those are still current
Absolutely.
board precedent.
Yes,
there has
Your
been
Honor.
no shift.
No shifts whatsoever. In fact, with all the shifting of Attorney General decisions
In a
lately,
lot of immigration contexts.
those have remained constant and did not seem to have the political ups and downs that some of the other decisions had.
Okay.
If there are no further questions, thank you, Your Honor.
All right. Thank you very much. Mr. Schrank.
Briefly, in response to the question about Chevron deference, this court in WGA versus Sessions refused to do the Chevron deference, but said it's an open question. But interestingly, that footnote suggested that this court was inclined not to follow Chevron deference, primarily because they said that the whole argument between particularity and social distinction is circular. To be socially distinct, you are now pointing out a very limited amount of particularity. I invite you to read that footnote. It's footnote number 2 in the WGA v. Sessions case, where this court says very clearly they are questioning Chevron deference in this kind of case because of the difficulty it poses for a particular social group and the exclusion of groups that would normally be accepted as particular social groups, because you are defining the size and you are defining the distinction part of it. The argument that DV was withdrawn, I've already argued about that and told you my thoughts about that. But on relocation, Professor Gutierrez Rivera testified to relocation in a country as small as Honduras is very difficult, if not impossible. The economic hubs of relocation are the big cities, and there's no program available in Honduras to help someone relocate or go to a different part, and there's no protection in Honduras for those people who are victims of domestic violence. All of that is in the testimony. All of that goes to that whole question that is raised about whether or not there's relocation. Finally, I would ask this court to please consider humanitarian asylum. Humanitarian asylum is designed for those people whose past harms cannot be projected to future harms, but they're at future harm from someone else. I cited a First Circuit decision which says that there is no law that says that humanitarian asylum must be raised before an immigration judge or the BIA before the circuit court can address it.
Thank you.
Thank you.
Well, thanks to both counsel. The case is taken under advisement. Our fourth case for argument this morning is BD versus Samsung SDI. Mr. Bowling, whenever you're ready, come on up.
Good morning. May it please the court. My name is Neil Bowling. I am counsel for appellant Samsung SDI Company. This is a products liability case in which the plaintiff alleges that he was injured when an 18650 lithium-ion cell manufactured by SDI exploded in an e-cigarette device in his pocket, and he then sustained burns.
Mr. Bowling, if the plaintiff was instead injured by a battery that was part of a power tool and not the E6, as I understand, SDI sells batteries to component manufacturers that put them in battery packs, and then some of them are sold in power tools. So if the fact scenario was that the plaintiff was injured by a battery pack exploding in a power tool, in that case, would you concede personal jurisdiction in this case?
No, we would not. For the reason, Your Honor, that the stream of commerce theory that the district court embraced and upon which plaintiff relies in his briefing requires an expectation that the forum will, that the product will arrive in the forum, and there has to be.
So let's say that, hypothetically speaking, let's say that discovery would show that Samsung sold these batteries to a component manufacturer, and as part of that give and take, the component Samsung asked them, okay, where do you sell these? And Samsung says, oh, we sell them to Black & Decker. And Black & Decker, by the way, does business throughout all 50 states. Okay, and Samsung's like, that's great, because we want to grow our market in the United States. Would that be sufficient?
It would not, Your Honor. And again, there still has to be some minimum contact. There has to be some effort by the manufacturer to reach out to the forum. And that's what's missing.
And what case are you relying on for that kind of, I guess some people call it stream of commerce plus or enhanced stream of commerce? What cases are you relying upon?
Well, actually, Your Honor, stream of commerce never eliminated the requirement of minimum contacts or reaching out to the forum. It was simply one way that minimum contact could be shown. So simply selling a product to an intermediary who then incorporates the product into its own product and then sells it in some forum that is not the intent or the expectation of the original manufacturer. That is not minimum contacts. It's not any kind of contact at all.
So you're saying it's not enough that Samsung or SDI knew that that's where the products were going to. SDI had to somehow intend or actively market that in the forum state?
Actually, a couple of things, Your Honor, in response. The evidence before the district court.
I guess we're talking about just kind of,
Certainly.
because as I understand, there hasn't been any jurisdictional discovery in this case, right?
Correct.
Right. So if jurisdictional discovery were to show that Samsung knew that these components were going to go to Black & Decker, and they knew that in fact, they wanted Black & Decker to incorporate them because of Black & Decker enjoys a large market share in the United States, including in Indiana. You're saying that that's not sufficient? That
is not sufficient, Your Honor. And I think that the Supreme Court decision in Nicastro is informative on that point.
But as Justice Barrett wrote in the Seventh Circuit case, whose name I completely forget the moment.
JST.
She said that plurality decision was not controlling, right? She recognized it wasn't controlling.
Yes, but even without looking at any of the opinions, if we look at the formulation of personal jurisdiction that the New Jersey Supreme Court articulated, that was rejected by a majority of the Supreme Court, that is exactly the formulation that there was a majority for rejecting. And what the New Jersey Supreme Court said is that it is sufficient for jurisdiction if a manufacturer knows or should know that its products are distributed through a national distribution system that might lead to those products being sold in any of the 50 states. That was what a majority of the Supreme Court found to be wrong. Now, I understand that there was not a majority for any particular opinion, but there was a majority for rejecting that particular formulation from the New Jersey Supreme Court. And that, I believe, would be the scenario that Your Honor was asking about, where SDI sells to Black & Decker with the understanding that Black & Decker wants to maximize its sales, and therefore it's possible that Black & Decker's products may end up in one of the 50 states.
So there's a variety of verbal formulations here. The Sheehan case, recent case from our court, express aiming is one phrase. Near injury, even if predictable, not a sufficient connection. To follow up on Judge Lee's questions, what would be enough? Would it be enough if the lithium battery packs were sold directly to distributors in Indiana?
Your Honor, I would not concede that would be enough, but that would certainly be a different fact pattern, and a very different fact pattern than what we have here.
I'm sorry, did you say you conceded? You don't think that is enough?
I could not concede that would be enough for personal jurisdiction because, again, the other complicating factor that we have here is that plaintiff, or not, if not plaintiff himself, somebody way outside of several steps removed from SDI had to have misdirected this item. Therefore, even if SDI directed or shipped its 18650 lithium-ion cell to Indiana, which it does not, and that's uncontradicted. But even if it did, there is still a problem with the fact that the injury that resulted here was from somebody deliberately misdirecting the product from its expected use.
But isn't that happening ubiquitously? I mean, these batteries are available everywhere, as I understand it. And the district judge, in denying the jurisdictional dismissal motion, mentioned the ubiquity of the availability of these batteries. Individually, not just in battery packs or incorporated into other products, as in Judge Lee's hypothetical.
Yes, Your Honor, and with all respect to the district court, I don't think that evidence of ubiquity was in the record.
I know this was a jurisdictional dismissal motion, but there are allegations that these batteries are available everywhere, and this particular battery was purchased in the form in which it found its way into the pocket of the injured plaintiff from a retailer in Indiana. So one of your distributors sold it downstream.
Well, there's no question. Well, actually, Your Honor, if I may first speak to the ubiquity issue. Ubiquity is not the standard and never has been the standard. None of our Supreme Court precedents.
Well, right. It goes to the question of whether Samsung SDI was exploiting this market nationwide by selling its batteries into the stream, or delivering its batteries into the stream of commerce in the United States with the knowledge that they would be incorporated into products, as in the Black & Decker example, or sold at retail in the form of battery packs, if not individually, throughout the United States and all 50 states.
Yes, Your Honor.
So that, I mean, if it's common knowledge that you can get these batteries everywhere, then it's reasonable to infer from that kind of allegation that Samsung SDI was aware of that and was part of its marketing strategy.
Yes, Your Honor, and a couple of things I'd like to say about that. First of all, if we look at Mr. Shin's declaration, which was ECF number 9-1, I think it's at page 17 in the supplemental appendix, Mr. Shin makes clear that, and this is uncontradicted as well, that SDI has no way to know where these 18650 cells will show up in having been incorporated into some other product. It has no control over that. Once the sale is consummated, SDI has no expectation whatsoever as to where the purchaser is going to sell its product after it has been incorporated.
Is that remotely plausible?
I'm sorry?
Is that plausible?
Yes, actually it is, Your Honor, because
Samsung SDI is producing these batteries by the millions and marketing them worldwide, and is, the major supplier of these batteries. So is it plausible to think that the company doesn't know that they're going to end up in all 50 states in the United States?
Two things, Your Honor. First of all, I would have to contend that it is plausible. And number two, even if SDI could foresee that its 18650 cells would end up in Indiana, as our Supreme Court has said, foreseeability has never been a sufficient criterion for personal jurisdiction. It has never been adequate to show minimum contacts that are necessary for specific personal jurisdiction. So
Counsel, if I can ask you,
certainly,
kind of on a different tact, so you are arguing, as I understand it, SDI is arguing that there are no minimum contacts here. You are not arguing, and that's where you're putting that's the basket in which you're putting all of your eggs, right? You're not asking, for example, in Asahi, the Supreme Court kind of did a two-step, right? It said, well, were the minimum contacts, and even if there were minimum contacts, we're still going to look at the case for kind of overall reasonableness, And I take it that from your briefs and from your argument that SDI is not relying upon that second step. It's just confining its arguments to the first step.
well, in the briefing, that's true. For this reason, Your Honor, the reasonableness is the third prong, but it doesn't even come into play unless the first two are satisfied. In other words, it's not a way, if there is no purposeful availment and no relatedness to the purposeful availment, we're done.
Right. And that's what I mean. I mean, that is your sole argument. You're not arguing the alternative that if there were purposeful availment, that personal jurisdiction would nevertheless be unreasonable.
We think it would still be unreasonable, yes.
But I'm saying in your briefs, I don't see that argument.
It may not be explicitly in the brief. I think it was in the reply brief, Your Honor. No, I agree. It is not. I don't believe it appears in the opening brief. And if I may, Your Honor, just to be clear, we're not suggesting that SDI does not purposely avail itself of doing business in Indiana. It does. It's simply a different product. And again, that's a whole different ballgame. That's the ESS cell. But there is no relationship whatsoever between plaintiff's injury and that product. Your Honor, I think that I am down to coming up on 2 minutes, and I'd like to reserve the remainder for rebuttal.
That's
Thank
fine.
you.
Thank you. Ms. Jawari.
Good morning, Your Honors. May it please the Court. Through its distribution chain, Samsung is intentionally sending millions of 18650 batteries into Indiana. BD is an Indiana resident who purchased a Samsung 18650 battery in Indiana and was injured in Indiana when that battery blew up in his pocket. That's all that's needed to resolve this case. Under this court's stream of commerce precedent, Samsung purposely availed itself of the privilege of doing business in Indiana by sending 18 650s to Indiana. This court has repeatedly held that when a company sends its product into the stream of commerce with the knowledge that its products will reach a forum state's consumers, that company has purposely availed itself of doing business in the state.
So what would be the stopping point then? When would it not be personal jurisdiction?
With reference to
The battery. When would personal jurisdiction not be satisfied here?
So for a company like Samsung that is worth $350 billion and is flooding the US market with these 18650 batteries, I believe it's perfectly reasonable for Samsung to have to answer in every state, if it knows those batteries are going to every state, if those batteries are causing injury to the state's residents.
Is there any stopping point whatsoever?
With a company like Samsung that is flooding the US market with its products, I mean, the stopping point, Your Honor, would be Samsung restructuring its business model. Samsung restructuring its business model to exit a state. The Supreme Court has repeatedly emphasized in its stream of commerce, in its personal jurisdiction precedent, that if a company doesn't want to avail itself of the privilege of doing business in a state, they can exit the state's market. But I think Ford.
And how would they do so here?
Sure. So Samsung, in its contracts and connections with distributors, could write into its contracts that it doesn't want its batteries sold in Indiana. But I think the one thing that Ford makes clear is that the one thing a company.
And if Samsung did that, would you agree at that point that there's no personal jurisdiction for SDI in this case?
I think that would be a much more difficult case if Samsung wrote into its contracts that it didn't want its batteries to go to Indiana. That said, this court stream of commerce precedent, the key to it is knowledge. That's what it looks at. So this court could potentially still find that Samsung had purposely availed itself of the forum state. But I do think that the one thing Ford makes clear is what a company cannot do is sell thousands of exploding batteries into Indiana, and then when someone's hurt by one of them, tell them that they have to go sue in South Korea.
But
I'm
sorry, go ahead.
Do we know where Samsung's distributors are located in the United States?
I don't know where Samsung's
because you haven't had that
distributors are.
discovery, so we
have
don't know.
not had
Okay.
discovery, Your Honor.
And that's not in the declaration of the
I do not believe it is in the Shin Declaration.
Shin Declaration. Okay.
Yes. Under the U.S. Supreme Court's decision in Ford, BD's suit is sufficiently related to Samsung's contacts with Indiana, and that's because Ford held that when a manufacturer sends its product into a state and that product injures a resident of the state, that is specific enough to satisfy specific jurisdiction. I want to make one point on the discussion of the stream of commerce precedent, and then I'd love to make a few points on relatedness.
Counsel, if I could just follow up on what you said about, and in answer to Judge Brennan's question about what Samsung can do. And so you said that if Samsung wrote into its contracts that we don't want our batteries or any products that contain our batteries to be sold in Indiana, that you said that would be a much harder case. How is that, in your mind, how is that different from Samsung putting in their contracts, we do not want our batteries sold in any shape or form anywhere related to e-cigs?
Yes, so I think that is quite different. And the reason is that the purpose of personal jurisdiction, as the Texas Supreme Court unanimously recognized in LGB Morgan, which we cited in our 28J, is to determine whether the forum state may exercise power over a defendant consistent with the Due Process Clause. So really, it's a question of state power. State power is key. So when a company participates in the state market for a product, it enjoys the benefits and protections of the state's laws. Those benefits and protections then come with a reciprocal obligation, which is to show up in court when its product injures a state resident. So in that situation that you laid out, you would see Samsung trying not to participate in the state's market. And the relevant inquiry is Samsung's connection to the state. I'd like to
You'd
note,
have on the merits a counterclaim against the distributor for violating the distribution instructions.
correct, Your
under
Honor, that
state
seems
law.
quite possible. Yeah. So as to the stream of commerce discussion that we've had here today, I'd like to note that Samsung is essentially rejecting the Seventh Circuit stream of commerce theory. The Seventh Circuit has repeatedly held that when a company sends its product into the stream of commerce with the knowledge that its products will reach a forum state, that is enough for purposeful availment.
Let me follow up on that, because our law seems to have a criterion for knowledge, which you're embracing, then a criterion for targeting. And even in these battery cases that are across the country, those that rely on knowledge might find personal jurisdiction, but those that rely on targeting do not. Why is this not a targeting case?
Well, I believe that the ones that are specifically talking about targeting, you're referring to the lithium-ion exploding battery cases in particular. The ones that focus on targeting are stream of commerce jurisdictions, stream of commerce plus jurisdictions. So they abide by Justice O'Connor's concurrence. But this circuit, as then Judge Barrett pointed out in the JST oral argument and suggested in that opinion, abides by pure stream of commerce.
But then we have Ford, and now we've got the Sheehan case from 2022.
Yes.
Is 2022, is the Sheehan case a targeting case?
So I don't believe that the Sheehan case touches upon stream of commerce at all. I know that it discusses stream of commerce cases in passing, but it relies on clear guidance from Walden, Calder, and mobile anesthesiologists. So I don't believe that anything that it says about stream of commerce, this circuit stream of commerce precedent, is outcome determinative. Though I will say that it did seem like that case was quoting sections that come from stream of commerce concurrences, stream of commerce plus concurrences, not stream of commerce. But I don't think that the passing discussion in that case can overcome years of precedent to the contrary.
Is there a proof problem here in that the Shin Declaration says SDI never shipped, sold, distributed, marketed, or otherwise targeted, and the plaintiff responds only with a complaint? Or does that go to the request for further discovery?
A little bit of both, but I really don't think that there is that problem here. So we've alleged in the complaint that Samsung had, quote, intent and knowledge to sell to consumers in Indiana indirectly through its distributors and other companies. And that's at SA 6, paragraph 19. And everything we've seen, everything we've been able to collect really supports that Samsung is aware its 18650s are reaching Indiana. We've submitted evidence indicating that Samsung sells its 18650s to companies like Black & Decker and Milwaukee. And that's at SA 151 and SA 150. You can see the battery packs there, and they very clearly show Samsung 18650 batteries. And we've shown evidence that those batteries are then in products that are widely available at places like Home Depot. So to your question about the Shin Declaration in particular, we believe we can rely on the allegations and evidence because Samsung doesn't actually dispute it. The Shin Declaration disputes physical presence. If you look at SA 18 and 19, it says we don't have board meetings. It says we don't pay taxes in Indiana. It says various other things about direct connections to Indiana. And then it goes on SA 23 to say we don't make direct sales in Indiana and we don't market within the state. But what conspicuously that declaration does not deny is paragraph 19 of the complaint or any of the supporting evidence that BD has put on the table here. And Samsung never has, despite having opportunity after opportunity to do so, in its briefs even, say that it did not know that its batteries were reaching Indiana through the stream of commerce by being incorporated into various power tools that are widely available across the state.
Counsel, what seems to be lacking, though, in the record, at least kind of when I looked at, is what goes to Chief Judge Sykes's question, which is what Samsung or Samsung SDI knew about its use of batteries in the e-cigarette area. and what it did to try to address its concerns about that, to the extent it had any concerns, or whether, I guess one might hypothetically say it might have turned a blind eye to that because of how profitable its batteries are. I mean, I don't know, right? That's all, but none of that is in the record. And it seems like since the cause of action is arising out of battery use in e-cigarettes, it seems like the facts that Chief Judge Sykes was asking about are particularly relevant to this inquiry, and that's just really nowhere in the record. And so doesn't that support a notion that, given the lacuna of evidence in this particular very relevant area, perhaps some jurisdictional discovery with regard to that issue is necessary to inform the court with regard to what Samsung did or did not know about the e-cigarettes business use of its batteries?
So if the court disagrees with us today, we would certainly like to have jurisdictional discovery, but I think that the best way to think about the issue that you're raising, knowledge about the e-cigarette market, what Samsung was doing with respect to this e-cigarette market, is not a purposeful availment issue. It's a relatedness issue. I think that Samsung has very clearly purposefully availed itself of doing business in Indiana with relation to 18650s because it, through its distribution chain, indirectly, which has always been a way of purposely availing yourself of a forum since Volkswagen, has sent its batteries to Indiana. And this circuit has repeatedly adhered to Gray v. American Radiator, which is an Illinois Supreme Court case. And there, a manufacturer in one state sent its component part to a manufacturer in another state. And that company in the next state sent the good into the forum state, which was Illinois. And there was minimum contacts because the component part manufacturer knew that in the machine that its component part was going to get to the forum state. So I think there are certainly contacts here, and the issue that you are raising, but please correct me if you disagree, the issue that you're raising really goes to relatedness. And the reason why I don't think that there's a relatedness problem here really goes back to what I was saying before, which was the purpose of personal jurisdiction, the constitutional basis of this entire doctrine, which is state power. And the idea that when we look at targeting, when we look at stream of commerce, when we look at all of these things, we are focused on the defendant's contacts with the forum state as a whole. If you look to Ford, if you look to prior Supreme Court case law, what it is referring to is the state's market. And why it's referring to the state's market is because of this reciprocal obligation that kicks in as soon as a company like Samsung is availing itself of the state market. I think if you look at Walden, you'll see that it says the minimum contacts analysis looks to the defendant's contacts with the forum state itself, and that's reflected in a lot of other case law. And that's why the Supreme Court has always held, and Ford confirms, that sending a product into the state is enough for the state to entertain a claim that a resident of the state is injured by the product. In the specific context of exploding 18650 batteries alone, in the last year, Samsung's contrary argument has been rejected by the Sixth Circuit, the Texas Supreme Court, the Mississippi Supreme Court, and a number of intermediate courts. All of those cases have held that Samsung's intent to only reach particular segments of the 18650 market really isn't a jurisdictional question. It's a question for the merits. It's certainly a defense on the merits in a product liability case. But there's no support in the US Supreme Court or in this court's case law for the notion that has constitutional significance. I see that my time is running out. I have 2 quick points that I want to make, if possible. The first is, Judge Lee, you pointed out a hypothetical about a Samsung battery exploding in a power drill. I think that hypothetical really shows why the situation is, why Samsung claims that it couldn't have anticipated the situation. But if an Indiana resident went to Home Depot, bought a Black & Decker power drill, took out the 18650 battery, and was walking perhaps to his vacuum to put it in there, because we know these are interchangeable, and the battery exploded, I don't think there could be a reasonable debate about whether there would be personal jurisdiction there. There's no constitutionally material distinction between that case and this one, and that's because personal jurisdiction at its core is about a defendant's contacts with the sovereign state, not what a defendant might hope or expect about its products once those products are within the state's borders. And just a last point to end on, Your Honors. I just want to emphasize that adopting Sampson's rule would have some really troubling consequences. If unauthorized use precludes jurisdiction, a company couldn't be sued when a child ingests a drug that's intended only for adults. And if the defendant's intended submarket matters, someone couldn't bring a wrongful death suit for the recreational use of a prescription drug, like OxyContin. Purdue Pharma could simply say, we never served that submarket. And here, with a manufacturer that floods a state with millions of exploding batteries, people like BD who are injured by a product sold all across the state would have to resort to the courts of South Korea. There's nowhere in the US, under Samsung's theory, BD could sue. And I'll just add that the state itself would have to go to South Korea as well if Indiana's Attorney General wanted to protect its residents in its own state courts. It would be unable to do that as well. Thank you, Your Honors. If there are no further questions.
Thank you.
Thank you.
All right, Mr. Bowling.
Thank you, Your Honor. I want to address one thing in particular. This SDI has been referred to quite a bit in this case as Samsung. I want to be very clear that what we're talking about here with Samsung SDI company is not the Samsung of that people ordinarily think about.
You made that point in your footnote. You may continue.
Okay. The other issue here, Your Honor, is we are not contending that we're not advocating a theory of stream of commerce that departs from established case law. We are relying on the Supreme Court's formulation in Worldwide Volkswagen, where the Supreme Court did not speak of knowledge, but of expectation. The expectation on the part of the manufacturer that its product would end up in a particular forum. And that is what is missing here. The other thing I want to address, I believe that counsel mentioned some other cases that counsel characterized as rejecting SDI's theory. Those cases are very different. In those cases, I believe it was LG Chem had actually shipped 18650 lithium-ion cells into the forum. That is not this case. Finally, Your Honor, I want to talk about the request for discovery. The Shin Declaration is undisputed, it's uncontradicted. Simply saying we don't believe it, or we have some hunch or just some suspicion that he might be lying is not enough. Plaintiff has come forward with no evidence that would contradict the Shin Declaration. Any discovery would be a fishing expedition. That is not appropriate. We would ask that the court deny that request.
Can your client be sued anywhere in the United States for these exploding battery
I don't know,
accidents?
Your Honor, but that's really...
I mean, the logical conclusion here from your argument is that it can't be sued, your client can't be sued anywhere in the United States for any of these exploding battery cases.
Actually, no, Your Honor. What we're contending is that it can't be sued in a state like Indiana where it has never shipped or sold an 18650 battery. We are not speaking to the issue of whether it may or may not be able to be sued in a jurisdiction that is different from that.
Well, but the implication of that is that any foreign manufacturer that uses U.S. distributors can't be sued in the U.S. Because it never shipped or sold anywhere in the U.S. except perhaps the state where the distributor is located.
Actually, no, Your Honor. If there is evidence of targeting, if there is evidence of an expectation on the part of the manufacturer that it serve a specific forum, then that would satisfy the jurisdiction. That
suggests that jurisdictional discovery is appropriate here to understand what your client's expectations were.
Actually, no, Your Honor. I think that the Shin Declaration shows that there was no expectation of serving the Indiana market. But if there are no further questions, thank you very much.
Thank you. Our thanks to all counsel. The case is taken under advisement. And before we call our next case, the court will be in recess for just a few minutes. right, our next case this morning is United States versus Lawrence Lusk. Mr. Pennington, good morning.
Good morning, may it please the court. Chad Pennington on behalf of the appellant, Mr. Lawrence Lusk. This is a case, Your Honors, where the sentencing guidelines were sufficient and not greater than necessary to achieve the purposes of sentencing, specifically the statutory goals. In this case, the district court erred by finding that workplace violence data and studies that were not connected to Mr. Lusk's conduct justified a variance above the sentencing guidelines. Furthermore, the sentencing here did not reflect the basic facts of the case, which is Mr. Lusk's conduct did not pose any specific or direct harms to the people at his workplace. I'd like to start with whether the guidelines have been notably too low in this case. That was the district court's specific finding. When we look at procedural error under this court's jurisprudence, we have to consider whether the district court avoided extraneous comments and whether there was a sufficient and proper explanation grounding the sentence. In this case, it's not where the guidelines can't accurately capture the conduct at issue. That's far from it. The guidelines here provide for various levels of enhancement based on specific characteristics of both the offense and of the weapon. For example, a large capacity magazine would justify an enhancement. The specific characteristics of the gun, of whether it was stolen, whether there's an obliterated serial number. Then we certainly have the availability of Section 5K of the guidelines, which calls for potential enhancement if there's specific danger, specific threat posed by the conduct. I think the problem here, Your Honors, with the guidelines approach that the district court took was it effectively created a guideline out of whole cloth. It enhanced on the basis of its finding that the workplace, presence of the firearm in the workplace specifically justified the variance.
Well, I don't think that it's right to say that Judge DiGiulio enhanced the sentence as we use that term in the context of guidelines sentencing. He issued a non-guideline sentence based on a contextualized factor that was not captured by the guidelines, which is to say that your client introduced a firearm into the workplace. And why was that error to do that in the 3553A evaluation?
I think, Your Honor, the error is that the district judge said that it's the guidelines that the guidelines aren't capable of capturing the conduct. I think the guidelines are capable of capturing the conduct.
But they don't. I mean, there isn't a specific guidelines adjustment for guns in the workplace, right?
That's correct, Your Honor, there is not.
So the judge was taking into account a particular contextual factor specific to this case. Even though he didn't use the gun, he took it to the workplace and stashed it there. And so why is it improper or unlawful for the judge to consider that contextual factor when evaluating the case under 3553A? It strikes me as a very sensible thing to do.
Your Honor, I think that specifically to that question, the guidelines do, specifically Section 5K too, they do provide for an enhancement potentially if the firearm poses a specific risk to an individual, if it poses a specific danger. I think that would encompass workplace violence or workplace danger. I think we have to look at whether there was a substantively reasonable sentence here in the 3553A, not just with the use of the workplace violence studies, but also with respect to whether the actual sentence here as imposed reflect the conduct at issue. And if the district court is saying this is a particular kind of sentence that needs to go above the guidelines because it's reflective of firearm possession at a workplace or it's reflective of enhanced risk, and we look at this social data, Your Honor, that has to specifically connect to the conduct at issue. So I don't think it was improper for the district court to necessarily use workplace data. I think workplace data, it's available to a district court, as is any particular characteristic. It just has to be contextualized or tethered to the specific facts at issue here, or any individual sentence. And if the district court is saying he brings a firearm to the workplace, and we look at all this workplace violence and all this workplace data showing that there's hazard with respect to firearms, they don't connect to the specific facts of the case here. There was nobody that was threatened by the firearm. Mr. Lusk didn't threaten anybody. He didn't brandish the weapon. I certainly see where
But wasn't the district court looking at the potential risks of having a firearm on the work site? I mean, sure, after the fact, you can, the risk is that he would be incited enough or provoked enough to brandish, that he would be provoked enough to threaten someone with a gun, right? Wasn't the district court looking at the underlying risk?
Your Honor, I think that's correct. I think that there's probably innate or inherent risk that attaches to a firearm. It is capable of causing deadly harm. But I think, to begin, the guidelines capture that, and that's why it's a federal offense for specific target classes of people or in certain target classes of place or certain kinds of instrumentalities. But I think that that's true. The district court's looking at the risk, but the risk didn't connect to the proffered workplace data. So if the workplace data is talking about violence and homicides related to firearms, I think the number was 387, those specific risks weren't evident in this case, outside of just the inherent risk that a firearm brings. I mean, I certainly can see there's risk with the firearm whenever you bring it into an environment where there's other people present. But that risk, the inherent risk of the firearm, didn't connect with the actual data, which was showing the use of a firearm in a specific way. I'd also like to turn Your Honor's attention to the district court's analysis of Mr. Lusk's criminal history. The criminal history here at issue, the district court made a finding that the specific recidivism rate among firearm offenders, which seems to be demonstrably high, justified a basis for the district court here to go above the sentencing guidelines. What I think, Your Honor, was improper about that is there's case law in this circuit that says the district court can't scapegoat a particular defendant based on societal ills. For example, we've cited cases where if the district court has concerns with firearm violence or any sort of social ill, that can't reflect the basis of the variance. You can't impute the concern the district court may have with workplace violence or with recidivism rates among firearm offenders to the specific defendant here. That was not proper. I think that generally there's certainly the incapacitation goals that reflect sentencing, but the incapacitation can't be based on a sort of group characteristic, which would be, in this case, the incapacitation that seemed to be motivating the district court was primarily, as it relates to criminal history, Mr. Lusk's connection with being associated with other firearm offenders. Understandably, firearm offenders have this high rate of recidivism, but the guidelines themselves capture the recidivism. They capture the criminal history. That's what moved him into a category 6. He had the 18 scorable criminal history points. That's what moved him there. I don't think it was proper for the district court to apply a higher sentence based on recidivism that's already reflected within the guidelines. Your Honors, I see that I've met my rebuttal time. Thank you.
That's fine. Mr. Temkin.
May it please the court. Good morning, Your Honors. Eli Temkin for the United States. This court should affirm Mr. Lusk's sentence as both procedurally sound and substantively reasonable. At the end of the day, this was a 46-month sentence for a 5-time gun offender who most recently received a 34-month sentence plus another 12 months on revocation for committing the same offense of being a felon in possession of a firearm. Procedurally, the district court did exactly what it was supposed to do here. It calculated the guidelines range, it considered the parties' arguments, it didn't rely on clearly erroneous facts, it weighed the section 3553A factors, and it explained the sentence that it reached. There was no error in mentioning the workplace violence statistics. The district court is permitted to situate an offense in the broader context. Mr. Lusk argued that this was, I believe the exact words were, a benign situation or a fairly benign situation. The district court was situating it in context with the risks that Mr. Lusk created when he brought this weapon to his workplace, which was supposed to be gun-free, and when he left that weapon in a shared workstation in a wastebasket. That comment was nowhere near as egregious as comments where this court has reversed for an inflammatory or extraneous remark. Additionally, this court considers the explanation the district court provided as a whole. It doesn't just look at a single statement in isolation. Substantively, the 46-month sentence here was reasonable based on Mr. Lusk's criminal history and his offense conduct. The criminal history I mentioned before, and his recent federal offense, federal sentence, that wasn't enough to deter him from carrying a weapon again around a year and a half after he was released following revocation. The manner in which he possessed the gun here created additional risks, as the district court noted. The sentencing guidelines are not binding. The district court weighed the statutory sentencing factors, and there was no problem in thinking about the risks that Mr. Lusk created when he carried this gun to work. There was no error in mentioning the recidivism rates of firearm offenders. The court was saying firearm offenders recidivate at a high rate. Mr. Lusk recidivates even more than that. This was a comment about Mr. Lusk's recidivism, which to date has been 100%. The district court was not scapegoating Mr. Lusk for firearm offenders in general. If there are no questions, this court should affirm. Thank you.
Thank you.
Mr. Pennington.
Thank you, Your Honor. I would say that when we look at the district court's approach to the sentencing here, when he's talking about the rates of recidivism, the comment that he made is that Mr. Lusk is proving them obstinately or too high. It's Mr. Lusk that specifically is showing the recidivism too high. I think when you look at the transcript, when you look at the totality of the sentencing, it's the district court expressing frustration with firearm offenders and their high rates of recidivism and applying that specifically to Mr. Lusk. So I don't think we can say that it's solely a comment that reflects Mr. Lusk. It's also the district court's frustration with recidivism as it relates to firearm offenders more broadly. And we certainly understand the district court's frustration with that. Firearm offenses, they may have a frustratingly high level of recidivism. But I don't think it was appropriate for the court to express that frustration and then apply it specifically to Mr. Lusk's case. I think that, I don't know if it's as far as scapegoating, but I don't think it's specifically an appropriate factor when we consider sentencing. I think also when we think about the risks of the conduct at issue, it is important to consider that there was no specific risk here independent of the firearm. Again, a firearm themselves, just innately, there's risks attached with certain kinds of possession. But I don't think that risks of workplace violence were proper here. Data reflecting workplace violence when there was no workplace violence here. There was no brandishing of the weapon. There was no direct threat posed to anybody at the workplace. My understanding is at the workplace, the firearm was found in a trash receptacle and then promptly found by police. So I understand the district court's inclination to say that firearms pose a certain risk, but it can't connect it or situate it in connection with workplace violence. It just didn't occur in this case. For those reasons, we would ask that this court reverse and remand.
Thank you.
Thank you.
Thank you. We'll take the case under advisement, and thanks to both counsel. Our next case for argument this morning is Jason Peterson versus James. And actually, I think the defendant that's left is John Drennan, not Jamie James. So we'll correct the caption. Good morning, Mr. Flaxman.
Good morning. May it please the court. Your Honor is correct. The only defendant that the appeal is against is John Drennan. The plaintiff in this case is Jason Peterson. He spent an extra year in prison because defendant Drennan failed to do his job so that Mr. Peterson could be paroled. Drennan was a prison counselor at the Vandalia Correctional Center. When Peterson was coming up for parole, Peterson requested to be released to a halfway house called the Wayside Cross Ministries in Aurora. Drennan's job as a prison counselor was to take requests like that one forward them to the parole office for further review. If Drennan doesn't forward the request, it can't be reviewed. The prisoner cannot parole to that site he's requesting to parole to. So Drennan, in this case, has a gatekeeper role.
Mr. Flexman, is there any policy or procedure at IDOC that would require Mr. Drennan to submit Mr. Peterson's request of preference to the Parole Regulatory Group, or PRG?
The testimony from Officer Drennan is that when prisoners make requests for parole sites, it's his job to forward them. He has put forward testimony about, two different policies where he wouldn't do it. I can't point you to evidence that says a parole counselor has to forward every single address he gets, but I think that's what his job is. I don't think he's denying that he has, or I don't think he's contending he has absolute discretion to just throw out certain addresses that he's given. The theory is that he's the gatekeeper, and unless he forwards an address to the Parole Resource Group, it won't get considered.
Just to get the terminology correct, this form of release is not really parole.
That's right.
It's mandatory supervised release.
Yes, so if I could call it MSR, and that would confuse us more.
Yeah, right.
But yeah, the word is mandatory. There's no dispute that if Mr. Peterson has an approved host site, he is released. No one has to exercise discretion about that under Illinois law.
But it is contingent upon somebody approving the release site, so it's not mandatory in the ordinary sense of that word.
Oh, that's right. I mean, yes, we're not disputing that there is this necessary step of getting the host site approved.
And who sets this date? Is this an administrative date, or is this a court set date?
The date is set by the court. I think sometimes there's good time and credits like that, but based on the prisoner every prisoner in Illinois gets a sentence of prison time plus a certain time on MSR. Mr. Peterson has a 4-year MSR term. And so there's no dispute about what the date is when Mr. Peterson's MSR parole begins. So the only question is whether he met the criteria to be released on MSR, on parole.
And those criteria are also embedded in state law by statute. It's not some prison regulation.
There are both. So there are some conditions of parole that are imposed by the parole board. There are some conditions that are by statute. In this case, Mr. Peterson was required to be on GPS by statute. Some other parolees have that requirement that's not required by statute, but it's imposed at the prison level.
Okay, thank you.
And that was as a result of the nature of his conviction, the
Right.
GPS requirement?
Yes, so because he was convicted of violating an order of protection, he's required to be on GPS for the time that he's on mandatory supervised release.
And no discretion or variation in that as a result of the nature of the conviction?
Right, there's no discretion. The one argument the state or the defendant had raised below was that maybe he wasn't required to be on GPS by the time he was finally allowed to parole to this site, but they've withdrawn that and agree that under the law, under Illinois law, he was required to be on GPS. And in fact, the evidence is that he was on GPS.
Okay.
And that's, in our view, the key evidence is that once Mr. Peterson transferred to another prison and once a different prison counselor was reviewing his request, that prison counselor forwarded the request to the other office within the Department of Corrections. The request was approved, and Mr. Peterson was allowed to be released.
What about Mr. Drennan's testimony that the reason he didn't think that Wayside was available because he had a conversation with someone from Wayside and he had some conversation with someone from the parole group?
Well, based on the evidence I just referenced about what happened later, we know that whatever Mr. Drennan believed or claims to believe was incorrect.
But how do we know that? How do we know that at the time that Mr. Drennan heard that Wayside either was at capacity or had a different policy versus later on?
Yeah, well, we have evidence, testimony from Mr. Peterson that Wayside told him there's a bed available for you and we take GPS. So I mean, this is, if this is we have the same kind of evidence on both sides about that issue. And whether or not Mr. Drennan was truly relying on these beliefs is a question that should go to the jury, because especially where we have in black and white Drennan's response to the grievance that doesn't say, well, I know that you can't go to Wayside because they're a capacity or they don't take GPS. It says, per IDOC, there's a rule that says you can't go to a halfway house with GPS. And that's the reason that Mr. Peterson got at the time. That was the claim that I'm applying this rule that we now know doesn't exist.
Right, that suggests that Officer Drennan was mistaken. Does it support an inference of deliberate indifference?
The court's precedent from the Figs case and the Huber case, yes, say that a jury can find deliberate indifference when a prison official in a situation like this is so, their work is so ineffectual that it can rise to the level of deliberate indifference.
But that involved a miscalculation of a parole date, right?
Well, those cases involve miscalculations, but they stand for a proposition that once a prison official knows there's a problem and someone's not being released, they have a duty to do some investigation. And once Drennan's put on notice, especially once he's put on notice, that Mr. Peterson has a spot at this halfway house that will take him with GPS, Drennan has to do something more than just say, no, I'm continuing to apply this rule that doesn't exist. The language in deliberate indifference cases talk about substantial departures from professional judgment, talk about conduct that's so blatantly inappropriate. It's our position that a jury could take the evidence that Drennan was applying a rule that didn't exist and make those findings. The one other point I will make is that the defendant is relying on a different rule on appeal. This claim that Drennan wasn't allowed to submit a specific halfway house for review. We've pointed to the evidence in the record showing that the other counselor at the other prison did just that. And a jury could look at that and say, well, that rule doesn't apply either. And here is his second time trying to apply a rule that doesn't exist. It's clear that this is more than just a mistake. This is going against all of the, what we would expect from a professional in this situation. This is so ineffectual under the circumstances that a jury can find deliberate indifference. If there are no other questions, I'll reserve the remaining time. Thank you.
Fine, thank you. Mr. Sheffield.
Good morning, Your Honors. Jonathan Sheffield, representing Appellees. This court should affirm the entry of summary judgment on Peterson's Eighth Amendment claim because he failed to show as a matter of law that Drennan was deliberately indifferent to Peterson's efforts to find a placement for mandatory supervised release or responsible for investigating halfway houses. To begin, Drennan's conduct does not demonstrate a sufficiently culpable state of mind. Each time he was presented with a release plan, a request for a release plan from Peterson, he put that into the inmate tracking system. He passed that along to the parole division. And I understand that there are a few different terms being thrown around here, but my understanding from the record is the parole division had a sex offender services unit for GPS monitoring, finding locations for them, and the parole resource group that was responsible for locating halfway houses. So after that, Drennan was not contacted again about Wayside until he was in the role of a grievance reviewer in December of 2018. So that's 5 months between receiving this request and then getting a grievance about that. And in that time, the Field Services Office, which Drennan was a part of, had already submitted home sites with, according to Peterson, without any problems or issues in getting those passed along to the parole division for investigation. Now, unfortunately, those were not approved, and the date on which his mandatory supervised release began came and went without an approved residence. And that is the condition of release that Peterson did not have met until January of 2020. But I'll note that in the 9 months that he spent at Vandalia on mandatory supervised release, he communicated to Defendant Drennan 8 times, Defendant Drennan communicated to Peterson 8 times. It's reflected in counseling notes. And each time letting him know about, updating him on the status of the parole agent's investigations, reminding him of the parole agent's discretion, and even offering to speak to a potential host site. And in that time, in those 9 months, Drennan did not receive another request to name Wayside in a release plan. Just want to point out a couple of things. One, there's a difference between counselors like Janie James and field services, folks who are working in field services. Initially, there was a defendant in this case, Janie James, who Peterson testified that he had spoken to over 10 times about a request to go to Wayside. And he said that each time he was rebuffed. But this person is obviously not Defendant Drennan. I just want to make sure that it's clear that the number of times that Drennan even heard the term Wayside on this record is 2. One in June or July of 2018 when he passed along the homeless plan to the parole resource group, and then in December 2018 when he was serving as a grievance officer. And as to the point about when he heard from Peterson as a grievance officer, that of course his role as a grievance officer is to determine whether the grievance has merit for further review. And he denied that grievance, he suggested denying that grievance, and then that, of course, though, didn't have any effect on the parole resource group's authority and responsibility to locate a halfway house for Mr. Peterson. And, of course, his role as a grievance officer was not to investigate claims or to investigate halfway houses, as Mr. Peterson had requested in the grievance. That, again, was the responsibility of the parole resource group. And even if Drennan was mistaken or negligent in that process, he could not be found deliberately indifferent. Unless this court has no further questions, we ask that you affirm the summary judgment entered for Defendant Drennan.
Thank you. Mr. Flaxman. I think not. Thank you very much. Our thanks to all counsel. The case is taken under advisement. Our next case for argument this morning is United States versus Joshua Depage. Ms. Eisenman, good morning.
May it please the court, Vanessa Eisenman on behalf of Joshua Depage. With the limited time, I'd like to jump right into the related issues of waiver and remedy, which seem to be the government's primary opposition to this appeal rather than the merits. If this court agrees that the 851 predicate is invalid, then Mr. Depage's guilty plea should be vacated. Again, we concede that this is under plain error review, just like in this court's decision in Delator. This is something that everybody missed down below regarding the mandatory minimum, but there's a clear error regarding the overbreadth of the predicate, and that error affected Mr. Depage's substantial rights, just like in Delator, in that there is more than a reasonable probability that he likely would have proceeded differently had he known that the true mandatory minimum was only 5 years instead of 10. Again, he agreed to a binding 8-year sentence on count 1, which in all probability he never would have done had he known that he was only facing a mandatory minimum of 5 years. This is all over the record. Everybody recognized at the change of plea hearing, at sentencing, that the 851 was the reason that he agreed to this C1C plea agreement. So without that, he, in all likelihood would have entered an open plea or gone to trial, and he could have argued for a sentence as low as 5 years, and still, had very low probability that he would have gotten more than the 8 years, which was within what the government thinks would be the guideline range.
Well, the 851 enhancement was not the only subject of the plea agreement.
That's correct, but it
there
was
was more consideration than that. The government agreed to drop the 851 enhancement, which was being contested, and there was some uncertainty about whether the meth manufacturing conviction would count, and in addition agreed to drop the felon in possession charge.
Yes.
And agreed to a lock-in of 13 years.
Yes. But
which
again,
is pretty good consideration under these circumstances, and your
It is
client
if the-
acknowledged in the change of plea hearing, and then later when he sought to withdraw his plea on other grounds and the case went forward, that he understood the bargain, essentially.
No, I disagree on that. This is, first of all, the 851 was the primary consideration. The dropping of the count 2, all that did was lower his guideline range, which was irrelevant because he agreed to a binding sentence. The concurrent sentences, everybody thought that would net him a couple months at most. So the 851 was why he agreed to it. So this was only a good bargain if the 851 was valid. And in terms of what you just mentioned and things in the record, I went through these in the reply brief, and it's not as clear as what the government says. And I think the Crockett decision is actually a really nice distinction to show what this case is not. And this was not a bargain that where everybody knew that there was this potential issue with the 851 being overbroad, and that was bargained for. That happened in Crockett. In Crockett, everybody knew that the occasions clause, there was a circuit split on that issue. This was going to go up to the Supreme Court. This is all over the plea agreement. The defendant stipulated that he committed the predicates on 3 different occasions. It mentions the ACCA in that plea agreement. They talk about it in the plea colloquy. So this is all over the record that everybody knows that there's this potential issue that may change things, and that's why they did this bargain. That is not at all what happened here. The government points out a couple of things in the record that they say shows that this was waiver. And again, waiver, intentional relinquishment of a known right for strategic reasons. That's not this. He writes a pro se letter 3 years before his guilty plea. Mr. Depage is a letter writer. He writes the court, he writes his attorneys, and he's kind of a laundry list letter writer. So this is one of his letters that he says, again, 3 years before his guilty plea. And he just kind of puts this laundry list of stuff in there about why the 851 may be invalid. But if you look at it, his primary contentions are factual. I was wrongfully prosecuted. I had bad representation down below. I wasn't actually producing meth. He's kind of throwing that out there. This is never adjudicated because he has counsel, so the court is ignoring this, okay? The second thing the government talks about is I believe chronologically, he said he had this attorney, Peter Lynch, before his guilty plea, and Peter Lynch had to submit a letter to the court about his CJA voucher being about over the cap. And in that letter, he says, it's a sealed letter, he says, Mr. Depage provided me with some case law about the 851. That's it. No context of when, no context of what. Again, this could have been his laundry list that he provided him. We don't know what these cases could be. And then the biggest thing that I think you can tell why this was never really contemplated by any of the parties is in that hearing on his Attorney Daniel's motion to withdraw his counsel. This is after the guilty plea. This is record 85, the transcript. The whole thing is about purity. They're talking about this purity issue. So what happened was Mr. Depage didn't get all of his discovery before the guilty plea, but he knew that, and they went over that at the plea hearing, and he says, yeah, I'm fine. After the plea hearing, he gets more discovery. He finds something in that discovery that makes him think that the government can only charge him with meth mixture instead of actual meth. And he says that if the government can only charge him with a mixture, can only prove that he had a mixture of methamphetamine, then he's not under any mandatory minimum whatsoever, and therefore the 851 is invalid. So if you read that transcript, that's what they're talking about. So when Attorney Daniels says there is a potential defense to the 851, he says at trial. And it's all in this context of the purity. So the thought was, if he went to trial, he could try to prove that he only had a meth mixture instead of actual meth. And that way, if he did prove that to the jury, then he wouldn't have been subject to any mandatory minimum, including the 851. So again, Crockett, I really actually like that case. The more I read it, the more I like it, because two big things that were present there that are not present here is, first of all, there was a change in the law. Wooden came out after the guilty plea. Everybody knew that that was a possibility, and there was this change in the law. And this court's case law has been clear that if you bargain, knowing that there could be this future change in the law, then the appeal waiver holds. That is not what happened here. This court has no precedent regarding this predicate at the time or now. Nothing changed. We're looking at these plain statutes just in dilator. Same thing as in dilator, with on the face of these statutes as they existed at the time of the plea agreement and as they exist now, there is this facial overbreath that's really, really broad.
But if it's a novel question, it suggests to me that it cannot be plain error. And practically none of these questions about the approach, the categorical approach, are clear and obvious.
Oh, I disagree.
Such that the trial court can be charged with the responsibility of sua sponte, noticing an error and correcting it before
I disagree
proceeding.
Because this is exactly what happened in dilator. This is the exact type of thing. And then this court said in dilator, it's plain error, but when we look at the state statute and we look at the federal statute, it is really clear that one does not necessarily entail the other. Again, we're under Schuler, so there's got to be a close connection, right? And if this court were to disagree with that, it would be creating a circuit split.
Well, was there an appeal waiver in that case?
In which case? In dilator?
Dilator.
Yes. Yes. There definitely was. And, it's very similar to Defendant Rush's position in that case. There were some concessions regarding Chapman, but Rush was really, really similar.
And did the Delator opinion address the Worthen line of cases?
Not to my knowledge.
The circularity of backdooring merits arguments?
That's not about the validity of a guilty plea. Worthern is not about the validity of a guilty plea. That's what this court said in Nulf, and it distinguished it there. That was about the validity of a conviction. And if you're not challenging the validity of the guilty plea, then the appeal waiver holds. But this court has tons of case law, and it's cited in our opening brief, pages 15 through 18, saying that if you're challenging the validity of the guilty plea as being unknowing or the product of a mutual mistake regarding a big deal like the mandatory minimum, then if you find that error, then the whole plea goes out the window, including the appeal waiver. I'll save my 18 seconds for rebuttal. Thank you.
Thank you. Ms. Boyle.
Good morning, Your Honors. May it please the court, counsel, my name is Catherine Boyle on behalf of the United States. This is a case that should be resolved on waiver. Mr. Depage waived his challenge to his conviction and sentence by knowingly and voluntarily entering into a plea agreement with a clear appeal waiver. That express and unambiguous waiver remains in effect and should be enforced. As we've stated, citing Worthen and Carson and Crockett and other cases, Mr. Depage here is necessarily asking this court to engage in a circular exercise. First, to ignore his appellate waiver. Second, to reach the merits of the 851 issue. Third, to determine that the predicate is invalid. And fourth, to hold that the appellate waiver is void. The court should decline to do that. It can't be the law that an appeal waiver is enforceable unless the appellant would succeed on the merits of his appeal. That's why this court has only declined to enforce an otherwise valid appeal waiver in a few limited circumstances, such as where the sentence plainly exceeds the statutory maximum,
or there's been reliance on a constitutionally impermissible factor like race or when counsel is ineffective in negotiation of the plea agreement. None of those circumstances exist here, and in light of that, Mr. Depage argues that his plea agreement was not knowing and voluntary. But that is rebutted by the record evidence in this case, which shows that Mr. Depage believed the validity of the 851 predicate was an open question and chose to plead guilty anyways in exchange for significant benefits that were conferred. These benefits were substantial. They included, of course, the government's withdrawal of the 851 notice, which permitted Mr. Depage to manage his risk that the predicate might be valid. The government also agreed to move to dismiss the felon in possession account, which is something that is not addressed in great detail in the defendant's opening or reply brief. There was a large benefit to this. One of Mr. Depage's main points in his opening brief was that he would only have agreed to the above guideline sentence of 96 months because his range was 70 to 87 with the dismissal of the count and the withdrawal of the 851 notice to get rid of the 851 predicate. But without the dismissal of the felon in possession count, Mr. Depage would have faced an advisory guideline range of 84 to 105 months under an open plea to all three counts. The 96-month sentence that he actually received falls right around the middle of that range. Had Mr. Depage proceeded to trial and not received acceptance of responsibility, he would have faced an advisory guideline range of 110 to 137 months imprisonment, or 120 to 137 with a valid 851 predicate. And he also has an added benefit if he avoids having an additional count of conviction on his record, which this court has said is a benefit for plea agreements. The government also included an agreement to recommend that the undischarged state sentences should run concurrently with the federal sentence. And Mr. Depage avoided further risks that we haven't addressed yet here today. He avoids the possibility of an upward variance at the district court's discretion, and that's a real possibility. Mr. Depage would have been a prime candidate for a high-end guideline sentence or even an upward variance in light of his offense conduct, which involves walking the streets of Pekin, Illinois with a pharmacy of drugs and a firearm with a bullet in the chamber. And he also reaches for his pocket, his jacket pocket, which the record is not clear as to whether the firearm was in the pocket or elsewhere in the jacket, but he's reaching for his pocket when the officer is trying to detain him. So the offense conduct is quite aggravated here, which could be the subject of an upward variance. He also could be the subject of such a variance based on his extensive criminal history and record of failing to comply with conditions of supervised release and confinement. So Mr. Depage has locked in this 96-month sentence in the middle of the guideline range that would apply under an open plea and avoids an upward variance that could quite possibly have occurred. He also avoids the possibility raised by his attorney that if certain relevant conduct were considered, because Mr. Depage had noted that he received, I think, about 2 ounces of methamphetamine at a time from his dealer and sold about a quarter of an ounce a day, that he could have had a higher base offense level on his possession with intent to distribute methamphetamine count once that relevant conduct was taken into consideration. So this is really a plea agreement that has just a broad scope. He achieved all these benefits while cognizant of but choosing to forego the potential 851 challenge. He raised questions about the validity of the predicate prior to pleading guilty, both via the pre-plea pro se 851 challenge and in consultation with his attorney.
He had a whole succession of attorneys.
He did. He started out with the FPD, but they had a conflict. Then he had Mr. Daniels, and he had Mr. Lynch, and then he had Mr. Daniels again, and then he had Mr. Rentisi for sentencing.
And lots of pro se communications with the court.
Many pro se communications with the court over the course of and he was a very strong advocate for himself in raising every claim that he potentially saw.
He wore everybody down and got a good deal.
Yes.
Basically.
I think that's a valid interpretation.
Was a good advocate for himself.
I think that's a valid interpretation of what happened here, Your Honor. It seems that he advocated for himself very wisely. I think when you read Mr. Lynch, his attorney's letter in context, speaking about 851 objections and the large number of phone calls and visits he had with Mr. Depage, you can tell that he discussed these issues at length. He didn't just read Mr. Depage's objections and never respond to him.
How do you respond to counsel's argument that when Mr. Daniels was raising the doubts or the potential viability of a defense against the 851 notice, that they were talking about purity versus, what the categorical approach?
Yes, Your Honor. Well, first of all, here where Mr. Depage did not try to withdraw his guilty plea on this basis below, the court is reviewing for plain error, and it is, I apologize, it is Mr. Depage's burden to show that. I don't think on this record that he has. First, when you look back sort of to the pro se challenge to the 851 notice, which just shows what he was initially thinking about all these things, he points out, there's no methamphetamine being produced. The state statute is very broad and encompasses a wide variety of actions because of the word participation. His objections go exactly to the objections he's bringing up in this appeal. And I think that should inform our interpretation of what Mr. Daniels is saying at the later status hearing when he discusses the issues that he had considered with the 851, potential 851 objection, which makes sense here because we know based on the record that Mr. Depage discussed it with him. Mr. Depage brought every complaint he had up about his case at every opportunity, and it appears to have been extensively litigated. I just want to briefly address De La Torre. De La Torre is a different circumstance. First, as to Mr. Chapman, the defense admits in its reply brief that the government conceded there that the plea would not be knowing and voluntary and the court accepted the concession, that the plea would not have been knowing and voluntary if the predicates were invalid. And that wasn't the only consideration. Both for Mr. Rush and Mr. De La Torre, one of the primary reasons this court found that the pleas were knowing and involuntary is because they didn't think there was any strong possibility in that circumstance that the defendants would have pled guilty without believing that these 851 predicates applied. That's just not the case here. We have every indication from the record that Mr. Depage was planning to plead guilty in this case, and that he knew that the 851 predicate was an issue. He just got a good enough deal to make it worth it, regardless of whether or not regardless of whether the 851 predicate was valid in this case. He wouldn't have really gained that much more or anything more, in my opinion, by challenging it. And then additionally, both the judges at Mr. Chapman and Mr. Rush's sentencing in De La Torre indicated that they were a little bit troubled by the amount of time the defendants got under these plea agreements, which suggested they might have given them a lower sentence. There was no indication from the judge on the record here saying anything of that sort. The judge essentially indicated that he thought this was a pretty good deal for Mr. Depage and that it was a reasonable way to handle the entire issue. Your Honor, if there are no further questions, we'll rest on the arguments in our brief and request that the court affirm.
Thank you. Ms. Eisenman, we can add some time to her clock.
I'll still try to be quick. I know we're all hungry.
Thank you.
Just real quick, again, I think what we get a little tied down in the weeds. Bigger question: why wouldn't he have litigated this if he knew about this issue? Why wouldn't he have brought this up? Why wouldn't he have challenged the 851 before the guilty plea? Why wouldn't he have moved to withdraw on these grounds in the district court if he knew about this? He would have. There would have been no downside to it. Either he wins, in which case he doesn't have this mandatory, he only has a 5-year mandatory minimum, or he loses and presumably the government would still give him the same deal. Otherwise, I think that would be a pretty big ethical problem. So why wouldn't he have done that? And again, this is why you know that Attorney Daniels was not talking about this type of issue. He wasn't talking about manufacturing, wasn't talking about analog, because he didn't. As soon as Attorney Daniels withdraws, we get a new attorney. And what does he move to withdraw his guilty plea on? Grounds that are not at all an issue in this appeal. He's talking about discovery. He's talking about the purity issue. He's not talking about this 851. And again, why wouldn't he have done that? Why wouldn't he have done that if he knew about this? There's no strategic reason for him to do that. Waiver should be very narrowly construed against the defendant. This case is like De La Torre. He would have gotten a much better deal had he had challenged that 851. It gets wiped out. He's got 5-year mandatory minimum, and he's got his appeals back. He could have argued for a lower sentence, and if the judge decides to give him a higher sentence, well, then he still has his appeal. So it is not the case at all that he got a good deal with this. So thank you for your time.
Thank you.
All right, thank you very much. Our thanks to both counsel. The case is taken under advisement. And our final case for argument this morning is United States against Tyler Thompson. Mr. Pennington, welcome back.
Good afternoon. I think it's still morning, but good morning, may it please the court. Chad Pennington on behalf of the appellant in this matter, Mr. Tyler Thompson. This is a case where the district court imposed a 235-month custodial sentence when the statutory maximum was almost equal to that at 240 months, and that was based on Mr. Thompson's very limited criminal history and based on what we think are some inappropriate factors the district court considered at sentencing. I would like to start before the merits on the issue of waiver. I don't think that this is a case where the court can apply waiver. The government cited that in their response. I think waiver, generally the standard is whether waiver can be divined from the record at the sentencing hearing. And I don't think that this is the type of case where it could be divined from that. The trial counsel specifically said that he wanted to preserve Mr. Thompson's appellate rights. He specifically said that. I understand that there was some colloquy about mitigation and the district court's treatment of the mitigation, but I don't think that the timing of that particular colloquy would demonstrate an intent, for whatever strategic reasons trial counsel may have had, of waiving the right to bring a meritorious appeal here. So initially, I do not think that this case would be procedurally barred under the waiver doctrine. We cited the Patel case. That's a case where there was a waiver to be found, although the colloquy was, I think, fairly similarly situated in the sentencing hearing as here. It was before the finding, it was before the actual imposition of the sentence and before the discussion of the notice of appeal. I think there were specific facts unique to that case. I think as a general principle, the court should apply the Garcia standard, and that is you look to whether there's a waiver as it relates to after the imposition of sentence, but before the notice of appeal is considered. I think under these facts, we don't have waiver.
So, Mr. Pennington, I guess my question is, what is really the real-world difference? I mean, if the judge, before the judge announces the sentence, says, you know, have I addressed each of the mitigating arguments of mitigation, or is there anything I've left out? And defense counsel says, no, judge, you've addressed all of them. Okay, well, then here's my sentence versus this is my sentence. By the way, before I announce my sentence, did I address all of your points in mitigation? What's the difference?
I think the distinction is just that, Your Honor, that it's really difficult for trial counsel to know how the mitigation's been assessed before the sentence has actually been announced.
But that's kind of a weighing concern of the mitigation factors, right? Versus, I kind of think of the question, you know, I think the judge said, have I adequately addressed each of the parties' respective arguments? To me, that rings more of kind of a procedural checking of the box. Okay, so you raised 5 arguments in mitigation. Did I at least address them all? Isn't that different from what you're saying, which is how a judge weighs the various arguments in order to arrive at the eventual sentence?
I think there is a distinction here, Your Honor.
And so would you agree that the defense counsel at least waived the first item, that is, the checking the box, that the judge correctly, whether the judge actually dealt with all of the mitigation arguments that defense counsel raised? Would you agree that that is waived?
I would say, Your Honor, that to the extent anything could be gleaned to have been waived here, it is the portion of the hearing where the trial counsel and the district court engaged in the discussion, and the trial counsel said, yes, Your Honor, you have considered those. But I don't think he's waiving them I think he's addressing to the court, yes, I've raised these issues. I understand that you have considered them, but I don't think that that's waiver from this particular record, saying that there's no intent to raise an appeal moving forward. Well, if that answers your question.
Why doesn't it waive the procedural error argument about whether the judge adequately considered XYZ arguments in mitigation and leaves only the substantive challenge about, as Judge Lee states, the judge's weighing of all of the inputs into the sentence and in determining the appropriate sentence? It leaves you with your substantive argument, but eliminates all the procedural arguments.
Your Honor, I think because the procedural arguments include whether the district court considered the extraneous facts or whether it relied on improper or erroneous factual material, That's part of the procedural analysis. I think that is slightly different here than weighing. When the district court asked Mr. Thompson's trial counsel, I think what the trial counsel is trying to say is, yes, you've broached my argument, but I don't think what he's trying to say is, you haven't not relied on some fact that we would consider improper. And I think that would constitute no procedural waiver here.
Well, the only thing that happened after that colloquy, the waiver colloquy, is the pronouncement of sentence, right?
I think there was additional material after the colloquy, after the specific discussion of whether I've weighed it, and then it's the point where the district court, I should say, that's when the district court began to engage in what I would say was its weighing of the sentencing factors. So I think there was something that happened subsequent to discussion of the district court asking trial counsel, have I considered your mitigation arguments? Also, Your Honors, the district court here failed to address the sentencing. The district court certainly imposed a guideline sentence, understandably, but the difference here is the district court didn't consider the defense counsel's argument raised at the sentencing is that there's a fundamental flaw in this particular sentencing regime when it relates to the predicate issues here and the conduct issue. The trial counsel said, and he offered the report saying that the sentencing commission itself is saying that this particular sentencing guideline has major flaws and it's somewhat outdated, and it's not necessarily rooted in the current national experience or in empirical data. That was the report that was proffered in addition to the sentencing memorandum, and the district court just simply didn't consider it. There was a discussion of the factors of content, community, and conduct, but he didn't look at the thrust of the defense counsel's argument, and that was specifically, this is a flawed sentencing guideline, and it's not based in empirical realities. The district court didn't engage with that discussion of any kind. Additionally, we've raised a procedural argument about whether the district court considered what we would say were extrinsic or extraneous facts. That's the finding of the district court that Mr. Thompson was not under the influence when he engaged in the conduct. The government, their argument effectively was this was not an abuse of discretion, that there was two plausible realities here. I would say the facts show that there really is one reality that was available to the district court, and that is that he cannot make a determination about whether Mr. Thompson was under the influence at the time he engaged in conduct. It's simply unknowable. I think it is fair to say that the district court speculated in making that finding that he's under the influence. The testimony from the agent, from Agent McAdams, was simply, I don't know. He also indicated that he's not an expert. He didn't engage in the online investigations. He's not an expert on the platform that was used, the Kick online platform. Agent McAdams, just like the court, just like everyone there, really wasn't in a position to determine whether Mr. Thompson was under the influence or not. I would save my remaining time for rebuttal.
Thank you. Mr. Whalen.
May it please the court. Good afternoon, Your Honors. Nathaniel Whalen here on behalf of the United States of America. I think there's some confusion about the arguments being raised here. We kind of have three different streams. We have the, have you considered my principal arguments in mitigation procedural question? I think defense counsel's rightly conceded that's been waived at this point. That's waived at page 60 and 61 of the sentencing transcript. There's no further weighing of the 3553A factors after that. All Judge DiGiulio does at that point is say, and this is the sentence I'm going to impose. Judge Lee, to your question about what's the real world difference between asking that before saying here's the sentence and after, is I'd say Judge DiGiulio is in a position now where if he did miss a principal argument in mitigation, he can consider that before he announces his sentence. So, instead of saying I'm going to impose a 235-month sentence, now have I considered your principal arguments? He says, here are the 3553A factors. Have I considered them? Defense says yes. He says, okay, phew, I didn't miss anything. If he had missed something, he could have factored it in and changed the sentence. This is a clear-cut instance of waiver for principal arguments in mitigation. If this court is going to adopt defense's reasoning and say that you have to ask the question after imposing the sentence, I think it would be useful for the district courts to say that timing is dispositive, but that's not consistent with this court's case law. It's not consistent with the principles. It's not consistent with real-world analysis. So that's the first procedural argument. The second procedural argument is, did the district court rely on clearly erroneous facts? That's not waived. The district court didn't say, did I rely on all clear facts or clearly correct facts. The court asked a specific question: have I adequately addressed each party's respective arguments, including any made in mitigation? I don't think the defendants waived an argument that the court relied on a clearly erroneous fact, but the court didn't rely on a clearly erroneous fact. As Agent McAdams testified, if an individual is going to be under the substance abuse, under the influence of substances at the time, it's probably going to be incoherent text messages. And defense counsel conceded that point when questioned by Judge DiGiulio. Defense counsel concedes, Judge, we agree with you, it probably would be incoherent. And Judge DiGiulio says, okay, well, none of these are incoherent, so it seems the defendant was not under the influence of drugs at the time that he made these chats. Additionally, he tells probation that he's using meth once a month, reproduced 15 days roughly of texts. So kind of as a matter of common sense, he's not under the influence of drugs when he's sending all of these texts. Then there's the third kind of line of argument that I believe defense is raising as to whether the district court appropriately weighed the 3553A factors and weighed the mitigation arguments. That's also not waived. If a defense argues that, Judge, you should impose a lower sentence, the judge doesn't, that's preserved, that's what this court has said, that's a substantive argument. Here, Judge DiGiulio extensively went through the 3553A factors. They talked about how this particular defendant distributed CP, was told by FBI to stop. 4 months later, he's doing it again. And he has what Judge DiGiulio describes as some disgusting materials on his particular devices. Judge DiGiulio imposed a within-guideline sentence. It wasn't substantively unreasonable. Unless this court has any further questions on any of these issues, we would ask that you affirm the sentence.
Thank you.
Thank you.
Mr. Pennington.
Thank you, Your Honor. To begin, I don't think that the record reflects that defense counsel at trial said it would be incoherent. I think the reflection, and this is a very granular distinction, I'm just offering it for context, that it wouldn't have demonstrated a mistake in the typing. I don't think he said it would demonstrate incoherence in typing. The reality is you have somebody who says they're using monthly, but they also have this demonstrated history of use, and the district court here ordered more further treatment. I think the record's just simply incomplete as to whether once a month, it certainly could have possibly been related to the time in which he's engaged in the prohibited conduct. It's speculation to say that it isn't. I'd also say that the government's argument is that district judge went through the 3553A factors exhaustively. I would disagree with that. He didn't go through Mr. Thompson's history of sexual abuse in the way that the record should have reflected. When he analyzed Mr. Thompson's history of sexual abuse, he did so in a way where he considered the government's claim that it didn't occur, the discounting of it. At that point, the PSR was adopted, those facts were assumed by the court, and there was nothing for the government to contest anymore that the actual sexual abuse had occurred. I don't think you could say that the district judge here exhaustively weighed the sentencing factors, that particular history and characteristic of this defendant, and that history of abuse and how it may have informed his conduct here, without giving it the type of weight it needed. And that was saying something more than, I've looked at it but the government discounts it. That wasn't sufficient here. This is a fairly protracted history of abuse that Mr. Thompson had. It allegedly went from the time he was 8 till he was 14, and it was the defense's principal mitigation argument. It demanded more treatment than that. So I would disagree that we have an exhaustive analysis of the 3553A factors. And for those reasons, we would ask that this court reverse and remand. This is a very high sentence. This is 235 months, almost 240 months for someone who has very limited criminal history, one scorable criminal history point. That's almost at the statutory max. We think that was an abuse of discretion. Thank you, Your Honor.
Thank you very much. Our thanks to both counsel. The case is taken under advisement, and that concludes our argument calendar for the day. The court is in recess.